Yes. My lord, I have lordship's kind indulgence to mention two connector writ petitions. My lord, one was the first writ petition was filed in.
Before the next.
No, I am not. I know. I'm not. Only my lord, my humble prayer before lordship. Kindly direct this matter to appear in the next circuit bench, because both connected matter affidavits in one matter is complete.
Motion or hearing?
See, it should be hearing.
Hearing.
No,
please
my lord.
mention before the. I do not know what.
No,
the business.
only one thing I tell you, lordship. When the first writ petition was moved, it was moved before my lord, Mr. Kaushik Chandra. His lordship directed, it was appearing under the heading motion. So his lordship directed that after giving evidence, exchange of direction for exchange of affidavit, his lordship directed that it will appear under the same heading. So it was to appear as motion.
Affidavits has to be
But
here.
as a motion. But
please mention before the next.
my lord,
circuit,
kindly, my lord,
because I do not know whether the. His lordship will.
my lord, my lord will not kindly not disappoint me, because she lordship knows a lot. Because only for this reason, my lord, I got a, my lord, as per the order of the honorable court, the district magistrate was to fix the rent as occupation charge. Initially, he fixed a rate. He fixed 9 crores. Thereafter, what happened on the
occupation charges?
Because the West Bengal
Acquisition not followed by.
no, not it became infectious. Then there was a settlement. Then West Bengal Electricity Board agreed to vacate the premises. Then thereafter, my lord, Justice Jason Gupta passed an order directing them, directing them to vacate within a stipulated period, and also directing the district magistrate to assess the occupation charges for almost 20 years. It was fixed, my lord, as per the, it was fixed. Then West Bengal Electricity Board, my lord, electricity distribution company, my lord, they made a representation that it should be reduced based on certain. Then it was reduced from 9 crores to 3 crores on their request without notice to me, which I challenged. They are representing that this property.
You are representing whom?
I am representing the owner, landlord. Now, my lord, my request is kindly direct the matter to appear, because I have high stake in this matter. My lord, my money is, my lord, for 20 years, I did not receive both the writ petition. I'm deeply obliged. I've given notice to other side.
My lord, may I pray, my lord, gracious, my lord, 5 minutes time today, my lord.
For what?
My lord, that hearing matter only on the ground, only on the ground of, my lord, maintainability, my lord, on the last occasion heard that the matter is maintainable before the tribunal.
That was at the time.
No, it has. It is to be.
To be mentioned.
My lord, it is to be. Why I say,
today it's a different day.
My lord, I understand, my lord.
Today is a different day. I can change my view.
But
that day.
But when it is a civil post under the state government, it must go. I will rely, my lord, on the judgments passed by our Honorable High Court. It is not even required, because the statute.
Contested matter.
My lord,
appearing under the heading here.
My lord, kindly
see how far because motions are to be given.
My lord, kindly, my lord, at any time, my lord, at any time, 5 minutes, my lord. Otherwise, my lord.
Appearing in the list.
My lord, kindly.
When it will be taken up, yes,
indeed. At any time, my lord.
Tuesday, my lord. This is that the results were withheld, my lord. That to school matter, my lord. Yes. My lord was pleased to accept the mentioning. Yes, my lord. My lord, my results were withheld pursuant to the direction of this honorable.
What happened?
My lord was pleased to accept the mentioning. The matter has not appeared, my lord.
Has not appeared.
My lord. My lord, kindly, my lord. All the students have been promoted to class 8, my lord.
Tomorrow it will not be possible for
the kindly, if a supplementary list be published, only the results portion. Let them publish the result. It was mentioned upon notice prior.
Why tomorrow it will not be available?
Let them publish the result at least, my lord. Whether I have been promoted or not,
let it appear tomorrow. I will consider. Yes. You appear virtual. If you are not physically present, you can appear.
Because
hearing.
No hearing, lordship. In this matter, there is a direction upon the police to submit a report. If matter will list, they will file report. Just
all right. Next circuit ways.
No, lordship, tomorrow. Only just if our purpose will be solved, lordship.
Tomorrow. Yes.
So, my lord, this is not praise. But this
Press.
case, my lord, the fact remains, my lord, 2019 matter,
You are mentioning for inclusion or it's in the list?
nothing in the list for the inclusion, my lord. The file was not traceable, my lord.
Now it is traceable.
Yes, my lord, the principal bench said that it has been forwarded to the circuit bench, my lord.
All right, hand over the slip.
My lord,
That can be traced out, it will appear.
my lord, may I be permitted to also hand over the my instruction? Because if I,
And what the instructions when the matter is taken up. If it is misplaced, you will be in difficulty. Because this is
right.
instructions given to you by the client. Please keep that, hand over the mentioning.
My lord,
grateful, man.
Let's call the list.
my lord, at any time, my lord.
Lordship,
yes,
may I be permitted to mention virtually, your lordship?
Yes,
Lordship, my learned senior mentioned this matter, it's item number 48. Lordship, our writ petition will be infructuous. A can has been filed in this matter. The assessment order has been passed, your
let me see
lordship.
how far I can proceed. Yes, call the list.
My lord, item number 104, my lord, may I be permitted to mention? I'm sorry, my lord.
104.
104. My lord, the urgency is the construction of a road in terms of the High Court direction. My lord, that construction has been stopped and police, because of certain ruckus created, this is a police inaction application. If my lord permits me to take
Construction has been stopped when?
any date, my lord, if tomorrow,
When it was stopped?
my lord, there is some urgency.
When it was stopped? Construction stopped when?
My lord, 19th of March, my lord, I had mentioned the matter twice last week and this
Let
beginning
me
of
see how
this week
far I
as
can
well.
proceed. Yes, call the list.
Lords, item number 1, my lordship, may kindly be put out of the list, my lords. We were instructed to ask for a withdrawal, but my lords, the interest has not been credited to the account. Simply out of list, my lords. Nothing missed.
All right.
I'm appearing on behalf of the bank.
Yes. This matter was mentioned by the learned advocate for the petitioner, stating that the petitioners are not willing to proceed with this matter. So, however, when this matter is taken up today, the learned advocate for the petitioner submits that he has been instructed by the petitioners to move the writ petition on its merit.
As the interest has not been credited. As the interest amount has not been
As
credited.
the
Lordship, yeah, Lordship, this the issue is already dealt by the revision bench. And in similar issues, that has been dismissed by the
Lords,
revision bench.
those
He
are,
says, no.
that is a different issue.
That is
This
a
is a,
different thing that can be considered on.
my
merit.
lordship.
He mentioned this matter because according to him, he submitted that the petitioners do not want to or wanted to withdraw this. For that it was directed to be appearing under the 82 mention. Now he says he wants to proceed. You can make your submissions when the matter will be taken up. You know. As the interest amount has not been credited to their account. Mr. You are appealing for the bank.
Yes, Lordship.
The learned advocate for the bank is present. He submits that the issue involved in this writ petition is covered by a decision of the Honorable Division Bench of this court. So stop paragraph. Let the matter go out of the list for the present. Yes.
Item 2, withdrawal. The interest has been credited, it has to withdraw.
So same issues, there it has been
Yes.
credited.
They are not credited,
You
here
are
credited.
appealing for the bank.
Yes.
You have any letter? No.
No.
The learned advocate appealing for the petitioner submits that the petitioners have instructed him to the learned advocate appealing for the petitioner submits that the instant writ petition has become infructuous due to passage of time, as in the meantime, the interest amount has already been credited
To the bank
to the
account.
bank account of the
My
petitioner. Stop. Recording such submission, WPA 1565 of 2023 stands disposed of. Bank.
Bank is represented.
Bank is represented by its learned advocate. Yes, next.
Deep cut.
Yes, three.
Lordship, I'm for the bank. Lordship, I represent Stevens.
This writ petition is not maintainable, Lordship.
But why it was directed to appear under the heading Privilege Act?
Administrative notice upon them.
Oh, administrative notice. It has not yet been served. I told that will take some time.
But Lordship, the writ petition itself is not maintainable.
But it has to be in their presence.
And Lordship, a judicial order has been prayed to be set aside in Article two
Sir,
twenty-six.
now the petitioner is not being represented by anyone. So they have to be, so a directed issuance of an administrative notice. So let that notice be served.
One council called me up, my.
Who?
Nalda.
Nobody is appearing today. So I'm fixing it in the next circuit bench.
Lordship, the
because
stay order is there against the bank, so the matter may kindly be fixed.
The
up
order
by-
of the DRT has been,
By the order dated. By the order dated. April 7, 2025. This court directed. An administrative notice to be served upon the petitioner. And the matter was directed to appear today, that is, bole aajke date. So, it appears from the record that the notice pursuant to the order dated 7th of April 2025 has already been issued. Puster, has already been issued on 8th of April 2025. So however, none appears for the petitioners. Puster, in view thereof, this matter before the next available circuit bench under the same heading.
Lordship, the stay order may kindly be vacated against the
Cannot.
bank, Lordship.
Yes, next.
Or
Put 7 out. This matter was directed to appear under the heading to be mentioned for correction of a typographical error which has crept in the order dated 7th of April 2025. In page 2 of the said order, the number of the writ petition was wrongly recorded as WPA 646 of 2025 instead of WPA 647 of 2025. Let such error be rectified. This order shall form part of the order dated 7th of April 2025. Other portions of the order shall remain unaltered. Yes, next. 4, 5, number 5. Has been wrongly recorded as WPS 646 of 2025 instead of WPS 648 of 2025. ঠিক আছে? Other questions. Next. Instead of WPS 646 of 2025 to be WPS 649 of 2025. That's a corrected to 649 of 2025. Next, for the next matter. No, after. 7 instead of WPS 646 of 2025, WPS 650 of 2025. Yes, next.
Yes, Lordship, I have mentioned this matter for correction. Your Lordship has, in this matter, directed the National Highways to consider their representation of the petitioner, Lordship.
Let's see.
But it should be respondent number 1, competent authority, because they have filed representation before the competent authority, Lordship.
Cannot be so, lords. If I can have my lordship for a moment, on page 19 of the writ petition. That was brought before my lordship, it was considered and then the order was passed.
No. Because your submission was recorded that this application was forwarded to
Yes,
project
yes,
director.
yes, my lords. Page 19.
But contempt authority cannot be.
He has
recorded
already
because
determined
Say
it.
that, you say
Ah.
that he cannot because the special land acquisition officer has forwarded it
Yes.
to you.
Page 19, my lords.
Special land to deal
You
with the.
forward to the special land acquisition officer. notice
Saying
to
that we
the
will not do it.
Yes, because this matter has been, the special land acquisition officer has forwarded it to you.
Already forwarded the 3G
That was a
estimate.
So you
mistake
say
on the
that
part-
it cannot be decided by you, you can again forward that end of the matter. But Mr. Mishra, I think it's.
No, my
better-
lords, I will explain. Page 19 for a
Alright,
moment.
so then let-
The 3G estimate has
decide that-
already been forwarded. Now, why will we go one step backward?
Alright,
Lordship then record an order in this regard, Lordship.
what?
That would amount to review of my lord's order
No, what?
without a review application.
I submit this, what I am submitting today.
This matter was mentioned by Ms. Singh, learned advocate representing the National Highway Authority of India for correction of a typographical error. She submits that in the order dated for typographical for correction of a typographical error, the order dated 4th of April 2025. She submits that this court directed the project director, National Highway Authority, to consider the application of the petitioner dated December 26, 2024. But the direction ought to have been passed upon the special land acquisition officer and competent authority land acquisition department, Jalpaiguri. First up, paragraph. Mr. Mishra, learned advocate appearing for the petitioner, opposes such submission of Ms. Singh. First up, he submits that
The respondent number 1 has already considered and then forwarded it to.
that the special land acquisition officer has already forwarded the
Was already considered and then forwarded.
special land acquisition officer and competent authority, after considering the matter, has forwarded the issue, has forwarded the representation of the petitioner to the project director, National Highway Authority of India. First up, after hearing the learned advocates for the parties, this court finds that there is no error in the order dated 4th of April 2025. Sir, stop. View thereof, no further order is.
State is represented.
State is represented by its lawyer. Yes, call the next matter.
Clearing तो नहीं हो रहा है ना?
Yes,
मतलब I'm seeking extension of the interim order, Lordship.
what is the challenge in the writ petition?
My challenge in the writ petition is this, my lord, the order of the demolition passed by the subdivisional magistrate.
Subdivisional magistrate, why?
Subdivisional officer, Lordship, subdivisional
Why? Is this
officer.
an encroachment on the highway?
No, my lord, the allegations on the part of the private respondent is this, my lord, the petitioner has been constructed the his residence, my lord, beyond the sanctioned building.
Why STO?
My lord, it's a panchayat area, Lordship. Panchayat area, Lordship.
Yes.
Lord, I take the appeal for the Lord Siliguri Jalpaiguri Development Authority.
My lord, I have served notice to.
Who is for the state?
I for the private respondent.
Private
Lordship. Other
respondent.
this matter is ready for hearing, then if your lordship extend the interim order, then short
Yes.
extension.
Affidavits have been exchanged.
Yes, exchanged, lordship.
The this matter was mentioned for extension of the interim order. First up, the learned advocates for the respective parties submits that the affidavits have been exchanged and the matter is ready for hearing. First up, the interim order. Which was, when the interim order was initially passed,
But the initial interim order passed on lordship.
22nd of February 2024.
Yes, your lordship.
The interim order initially passed on February 22, 2024. And extended from time to time is further extended,
Last
Uh,
on 19th February
is
2025.
further extended till the end of June 2025 or until further orders, whichever is earlier.
I'm grateful, Your
So list
Lordship.
this matter before the next available second page under the heading hearing.
Grateful. Your
Lordship, I'm for the respondent number 6 and 7, Lordship.
Yes, give your appearance. Yes, next.
For item number 10, I appear virtually on behalf of the petitioner.
Yes.
Lordship, in this matter, the interim order was firstly granted on the 10th of July. Lordship, it's a JAO and FAO issue. So your Lordship has granted stay till disposal in the similar matters in the division bench, like Girdhar Gopal Dalmia. If your Lordship can grant a similar order in this matter.
Standard DSA appear will be a short password kindly.
I'm extending the interim order. You have filed an application.
Yes,
Can
your
file.
Lordship. Yes, your Lordship.
What are the other applications?
Your Lordship, for extension of interim orders, all the other
Those have been
applications.
disposed of. Can one
Disposed of.
Yes, your
They have already been disposed of, yet
Why
they're
it is appearing again? Ashwin. Can 5 of 2025. This is an application for extension of interim order. Gustav, when the interim order was initially passed,
Lordship, 10th of July 2024.
the interim order which was initially passed on July 10, 2024 and extended from time to time is further extended till the end of June 2025 or until further orders, whichever is earlier. Can 5 of 2025 accordingly stands disposed of. Gustav, it has been submitted by the, it has been uniformly submitted by the learned advocates for the respective party that can 1 of 2024 and can 2 of 2024 were filed for extension of this interim orders and same has already been disposed of. The learned register, Jalpaiguri Circuit Bench is directed to ensure that can 1 of 2024 and can 2 of 2024 shall not be shown to be pending in the docket of this court. Yes, next.
Grateful, Your Lordship.
Grateful, Your Lordship.
Yes, call the next matter.
I'm for the petitioner lordship.
For,
Extension of
municipal
inter-
corporation.
extension-
I'm opposing This is a prayer for extension.
Why?
Now,
Lordship,
Lordship, this initial order was passed on 28 January.
January
2025.
2025,
There was a
thereafter
direction
time to time
upon us
extended,
to
lordship.
disclose- There was a direction upon us to disclose by way of affidavits all the documents on the strength of which the order of demolition was passed. Before to 17th February, we had given the opposition. Till date, they have not given the reply and simply
Reply,
extended.
just that you will file the lordship.
When you will file?
Lordship, today,
When you will file?
Without a building
Lordship,
permission, they are.
next circuit, lordship.
Yes, what is this matter? Yes, proceed.
Lordship, give me short parts of lordship. Give me short parts of lordship.
Proceed.
Lordship,
Without any plan, you are making construction and will not.
no, lordship, that is not true, lordship.
Where is the order impugned? Show me.
Yes.
Lordship, give me short parts of lordship. Mr. Mojumdar will appear in this case, actually.
Which Mr. Majumdar? Yes, pass over next.
Lordship.
Yes, pass over. Yes, next. Call the next matter. Call the next matter.
My lord, I am for the petition.
Yes.
My lord, in this matter, I retain liberty to file a supplementary affidavit, my lord.
Yes.
Well,
What happened?
because-
What is this matter?
The matter is, well, the
My lord, in
petitioner
this matter, my lord,
challenged
they have to made party, the SSC have to made party and
SSC.
Staff Selection Commission. my lord.
Commission.
Actually, the examination conducted by Staff Selection Commission and the successful candidate, they have challenged, they reached the
What is the issue? What is the ground of challenge?
Ground of challenge is that, my lord, the petitioner applied for the post of constable burglar in the respondent number, under the respondent number 3. And the one, after
application, my lord, he is called for interview. And after interview, he and one Indrajit Rai secured same marks, equal marks. But Indrajit Rai was get appointed by the respondent number 3, but the respondent petitioner is not.
So both of you have got same marks, but you have not been
No.
appointed. The other person has been
Other
appointed.
person has,
What does the rule say? If two persons get the same marks, then how?
We
And if
made
there
an-
is only one post, how selection is to
No.
be made?
actually My lord, post, there is there are- 20 post, vacancy 20 post, my lord. But we have made a representation and in
No, no, that
reply,
is different thing. I'm asking you, sir. If there is one post. Let us
sir,
assume
my lord,
there
can
is
we-
one post
Hmm.
and two candidates have secured equal
my lord,
marks.
in paragraph,
So
page number,
which of whom?
page,
Ask me, what does the rule say?
page number 117, my lord.
Yes.
They,
You have
they
quoted the
replied
rules
that
at page number 117.
117.
Yes,
They made a reply to the petitioner. my lord.
yes.
And they said,
Yes, yes,
last portion, my lord, paragraph
Yes.
number 3.
yes.
My lord, mark obtained in CBT part A. According to them, the part A, they said Indrajit Rai obtained the greater marks than the higher marks than the petitioner, my lord.
So yes, paragraph 2, the criteria has been mentioned.
Yes, my lord.
On the basis of that, it has been done. These facts have been stated. So where is the infirmity in the order?
My lord, when the normalized score is 42.750, my lord,
Sir, if I'm asking you, there are some basis. If both secure the same marks, there is one post. Both of them cannot be appointed. What
No,
is the
madam.
criteria? Some criteria has to be followed.
my lord.
Here it has been set out that in the event of tie in scores, this formula has to be followed.
Date of birth.
That has been followed. You have
alphabetical
not,
order.
there is no dispute with regard to that. What
Madam.
remains? The petitioner has challenged the now the petitioner is aggrieved by the fact that the petitioner has secured the same normalized score of 42.750 of
Yes.
42.750 with as কি বললাম? Because has secured the score, has secured the normalized score of 42.750. But the petitioner was not appointed to the post of constable
Bugler, BUG.
/ bugler, BUG, LER. Whereas one Indrajit Rai, who also scored the same normalized score of 42.750 was appointed. So stop. Paragraph, the petitioner submitted a representation before the concerned authority, ventilating his grievances, To stop. The DIG within bracket recruitment directorate by an order dated February 28, 2025 has held that due to the petitioner securing less marks in part A of CBT than the last selected candidate, the petitioner's name could not find place in the merit list. To stop, the said authority noted that as per the advertisement notice dated March 15, 2023, in the event of tie in scores of the candidates in CBTs, all capitals, such cases will be resolved by applying the criteria one after the another in the given order, comma, till the tie is resolved. It was further, the set criteria is set out here under. বলে এখানে না set out করে দেবেন এই পোর্শনটা, page 117. The said authority on facts found that the petitioner secured less marks in part A than the said Indrajit Rai. First up, there is no infirmity in the decision of the DIG within bracket Recruitment Directorate dated February 28, 2025. First of all, such reason this court is not inclined to grant any relief in favor of the petitioner. Disposed of next. 13 years.
13, my lord, I am,
10 minutes pass over, Lordship.
Lord, I am for the petitioner.
This matter.
Well, I am for the respondent number 8, the head
My lord,
mistress.
my lord, matter
Only 10
relating
minutes pass
to,
over, Lordship.
my lord,
Passover.
Grateful, Lordship.
Passover, yes, next. 14.
My lord, 14, I am appearing on behalf of the petitioner. My lord, 14 and 15. My lord,
Yes, what do you want?
14 and 15. My lord,
Yes, what do you want?
service has not been completed, my lord.
Service not completed. Service upon whom?
My lord, the next.
Service
My
upon
lord,
whom?
the first one matter, my lord, the 13. My lord, the private respondents, because my lord, the concern, my lord, the Shikha Kendra, and my lord, the mission director.
The learned advocate appearing for the petitioner submits that the service is yet to be completed. To stop as prayed for by the learned advocate for the petition is this matter before the traveling circuit bench. Yes, call the next matter. Next matter, same thing.
Well, the issue pending before the honorable division bench. Government leader has been served, but the issue is still pending before the honorable division bench. And my lord, presided over my lord justice, my lord, the honorable justice Hodistan, and his lordship was my lord hearing completed, and the judgment reserved. Due to my lord, his lordship, my lord, the elevation as the chief justice, my lord, the judgment has not been delivered.
What is the issue? What is the issue involved?
Issue, my lord, in respect of all the petitioner pray for delayed payment of interest in respect of area pension, which was not paid. The ballot pursuant to larger bench judgment and one of the judgment appeal.
That the issue involved in this writ petition is pending before the honorable division bench. First up, it raised that this matter be adjourned till the decision of the honorable division bench. First up, in the light of the submissions made by the learned advocate for the petitioner, let WPA 729 of 2025 go out of the list with liberty to the petitioner to pray for inclusion after the matter pending before the honorable division bench is decided. After the issue pending after the issue pending before the honorable is after the matter na kore, after the issue pending before the honorable division bench is decided. Yes. Yes.
My lord,
Yes, Mr. Banerjee.
16 a victory appear for the petitioner. My lord, in this, this is the second round of litigation, my lord.
Why you want leave? You have been engaged by your client. You are entitled to move. Why
Yes.
you have, why you are seeking leave of?
No, my lord. My lord, before I start, my lord, I invite your lordship to kindly come to page number 163. That is the earlier.
Matter.
This is a claim, my lord. Claim arising out supply of supply of materials at the time of COVID-19, my lord. Foodstuffs. There are several other matters which I have personally also appeared. Now, my lord, direction has been given upon the CMOH. Now, my lord, what happened? CMOH to heard the matter and dispose of my representation.
What happened after that?
My lord, what happened, my lord? I as a counsel, my lord, I was engaged in the principal bench, my lord, on 23rd of December
You could
2024.
not appear.
No, I could not appear. Now, my lord, my client over there. Now, my client sought for an adjournment. They have also recorded. They have also recorded on the next date. Council will appear, but a reason order has been, my lord, passed that they have unable to produce anything, my lord.
Yes, Mr.
What?
Madam, takes up page number 171. 171. On the reasoned order, it is clear, Malad.
What it is clear?
They appeared personally, the petitioner along with his son appeared, they could not produce any document.
Petitioner personally could not present his case properly.
But that is not stated.
As
there.
My lord,
of an advocate,
Well, that is
advocate
not
can
stated in the reasoned
place
order.
the case of the petitioner in a much better way.
It is not the case of the petitioners that they sought time to produce
Give
the
one
document.
more opportunity of hearing.
That
My
can
lord,
be done.
yes, my lord, this is what I was, even my lord, in the order of Justice Sina, it was mentioned that the opportunity should be given to the representative.
The client has engaged a very busy lawyer.
No, my lord, this was
What can
what
be
happened,
done?
my lord, the second last day of the vacation.
Client engages a busy lawyer.
No, 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 my lord, no. This is not the thing, my lord. Just give me a fair opportunity, my lord.
She has also submitted a written statement. That is annexed next there too. That is annexed at page number 172.
It's a money claim.
It's a
Yes,
money
my
claim.
lord. Yes.
Admitted or dismissed.
Yes.
Not at.
Which
Show me
you
the admission.
admitted? Which admitted?
Money claim.
They have been admitted or not? No, my lord, they had not been
Sir,
admitted.
If not admitted, it's very difficult in a
Yes, my lord. May I satisfy your lordship
Very
on that?
difficult.
May I?
I can give you an opportunity.
Yes.
But I do not know what will happen.
Yes, my lord. What happened? The second writ petitioner
Show
also
me the order directing them to consider. Which order?
163 page number. That is the order of Justice Sina.
Where is your representation?
Yes, my lord. Page number 152.
152 is the representation. 152 representation. Order is at page.
163, my lord, is
High
the
Court order.
High Court order passed
And,
by Justice Sina.
Where is the
Impugned order?
impugned order?
My lord, 171, my lord. That is, the order is 171, my lord.
So these statements were filed on 23rd of November 2024.
Yes.
Not on the date of hearing.
No, my lord, they're probably a typographical error, but that was on that date. As an officer of this court, I'm saying this because my client went over there. And my lord, what is the difficulty? In High Court, we can appear online. In Supreme Court, we can appear online. But in such kind of hearing, if we indulge that, give us a fair chance to appear online, but the same has not been done.
Infrastructure is coming up.
Yes.
Coming up now.
This is the whole difficulty.
There is
Was heard, but your submission is that she paid for an adjournment.
Yes, my lord.
All right. Page 1.
not stated.
The petitioner claims to have supplied food articles.
Yes, my lord.
Food articles.
Food products to the safe homes.
Food materials to the safe house.
Food articles and allied items to the safe homes during the COVID-19 pandemic. The petitioner claims to have submitted a final bill. Where is your final bill?
That
Claims
is
you have
11
submitted
lakhs.
a final bill for rendering such service for the period from 23rd of June 2020 to 20th of December 2020 for a sum of rupees 11,42,029. Paragraph. The grievance of the petitioner is that till date, the respondent authorities have not released the payment in favor of the petitioner. Alleging inaction on the part of the respondent authorities, the petitioner approached this court by filing a writ petition being WPA 2219 of 2024. Which was disposed of by a coordinate bench by order dated October 1, 2024 by directing the Chief Medical Officer of Health, Darjeeling to consider the prayer of the petitioners in accordance with the norms and guidelines that were prevailing during the COVID period by giving an opportunity of hearing to the authorized representative of the petitioners, the in charge of the Batashi Safe House, Safe Home, and Hati Hisha, HATIGHISA, Safe Home, and the Chief Medical Officer of Health who was in charge at the relevant point of time, under whose supervision, under whose instructions the food materials were supplied. Pursuant to the said order, a hearing notice was served upon the petitioner. Mr. Paragraph. Mr. Banerjee, learned advocate appearing for the petitioner, submits that on the date of hearing, he could Mr. Banerjee, learned advocate appearing for the petitioner, submits that he could not appear before the Chief Medical Officer of Health, Darjeeling, on the date fixed for hearing, as he was engaged in a matter before the principal bench of the High Court at Calcutta. However, it is not in dispute that the petitioner appeared before the said authority on such date. Mr. Banerjee would submit that a prayer for adjournment on the ground of her on the ground of her or his on the ground of her learned advocate was sought for, but the authorities, instead of considering the prayer for adjournment, passed an order. Mr. Paragraph. This court finds that the Chief Medical Officer of Health, in the order dated January 20, 2025, passed an order after recording that the petitioner, despite the opportunity, despite the opportunity for submission of supporting documents being given, failed to provide any documentary evidence in support of her claim at the time of hearing. Mr. Banerjee submits that the documents in support of the claim of the petitioner is lying in the possession of the petitioner, but due to the petitioner being and the petitioner could not produce the same before the authorities, as she only prayed for an adjournment. Full stop. Paragraph. Such submission is however disputed by Mr. Rahman, learned advocate appearing for the state, who submits that the petitioner was heard at the time of hearing.
Petitioner was present along with her son.
Was heard as she, along with her son, was present at the time of hearing. Full stop. However, the fact remains that the after hearing the learned advocates for the respective parties and after going through the materials on record, this court is of the view that a last opportunity should be given to the petitioner to produce the documents in support of her claim before the concerned authority. Full stop. Can you, Mr. Rahman, can you say, give a specific date so that Mr. Banerjee is here, he can check his diary and can say whether he will be available.
Mr. Banerjee issue a
No, my lord, as per the administrative
Banerjee, according to
convenience.
your convenience.
No, my
you
lord,
decide-
as per the administrative convenience, let
Mr.
them.
Banerjee, you give a date, Mr. Rahman assures
I'll-
that on that date, give me your date after checking your diary.
Just. My lord, this is so embarrassing.
No, I will not record. Give me a date.
23rd, my lord, 23rd of this
23rd
month.
of April.
Yes, my lord.
Mr. Rahman, this is not holiday of the government.
Obviously,
Please take up that. Otherwise,
23rd of It's a Wednesday, my lord.
Yes.
The circuit will also be functioning at that point of
No.
time.
sir, it's a difficulty if the circuit is functioning.
Not a difficult, it is to be heard by the CMO.
Yes.
Not
So
a
it's
difficult.
not the not a holiday in the hills that you have checked up.
Yes, it is not a holiday.
Today there is a holiday in the hills. Today there is a holiday in the hills. That is why I'm asking.
It is not a holiday in the calendar that I am looking at.
Today is a
Right
rainy
now,
day, a rainy day for us.
If any
Not holiday.
clear
Yes,
details
check up
are
for the state.
Please check up if there is any
23rd.
23rd, my lord, is not holiday. It is not
23rd
indicated.
holiday?
all right.
That can be.
Full stop. The COMH,
Darjeeling.
after hearing the learned advocates for the respective parties, this court fixes the date of hearing on April 23, 2025 at about 1 p.m. That will be convenient.
Yes, my lord, yes, yes.
At about 1 p.m. And such hearing is to be conducted by the Chief Medical Officer of Health, Darjeeling. First up, since the date and time of hearing has been fixed by this court, on the basis of the submissions of the respective learned councils, there is no necessity to issue any further notice upon the petitioner in that regard. First up, the the Chief Medical Officer of Health, Darjeeling, is directed to consider the claim of the petitioner in the light of the directions passed by the coordinate bench in the order dated October 1, 2024 in WPA 2219 of 2024.
Let him consider afresh. Once he has already considered, let him consider afresh.
Yes. You will consider the afresh.
That is.
কি বললাম? To claim of the petitioner afresh. The reasoned order shall be communicated to the any time limit was fixed there for communication. Was it
Yes, my lord.
indicated from the
Within
date-
90 days from the date of communication, the earlier, my lord, that is
of the date
paragraph
of
6.
Communication, so I fixed the date. So now I think the reasoned order shall be communicated to the petitioner within a period of 2 weeks from the date fixed for hearing. Full stop. For the reasons as aforesaid, the reasoned order dated January 2025, passed by the Chief Medical Officer of FAIL, Darjeeling, is set aside.
Grateful, my lord.
WPA number circumstance stands disposed of with the order and with the directions as aforesaid. With the above, with the aforesaid directions. Yes, call the next matter.
Grateful, much.
Thank you. Yes.
Lordship, item 17, I've been informed that service has not been effected.
Service not been effective.
That is
What do
why
you want?
Kindly keep this matter in the next circuit. Lordship.
This is an entirely civil dispute regarding land between the co-sharers and the legal heirs. Yes, the allegation is that his ingress and ingress have been
Private respondents are
against the
parties.
private.
Lordship, I do not have any information. The thing is, I'm not involved in this matter.
The learned advocate appealing for the petitioner submits that service upon the service
Then-
upon the private respondents is yet to be effected. The petitioner is directed to serve a copy of
Hello.
this petition, to serve a copy of this petition upon the respondents and file an affidavit of service on the next date of hearing, as paid for by the learned advocate for the petitioner in this matter before the next available circuit. Yes, next.
Item number 18,
praying for next circuit, my lord.
As paid for by the learned advocate for the petition, this matter before the next available circuit.
Grateful.
This date is represented. Yes, next.
Lordship, item number 19 is same case, Lordship.
19, same order, next.
My lord, only one indulgence, my lord. The affidavit of service, kindly give me liberty to file within the day, my lord. It has not yet been affirmed, my lord.
All right. On the prayer of the learned advocate. for
No, my lord,
the-
16, my lord.
Yes, yes. This is
Six.
16 which I have disposed of.
Yes, my lord.
It is 16 যেটা disposed of.
Yes.
On the
একটু
leave
affirm
is
করে
granted. একদম উপরে। On the prayer of the learned advocate for the petition, leave is granted to the petitioner to file the affidavit of service in course of this day.
Grateful, my lord.
Yes. For the next matter,
My lord, in item 20, I'm praying for next circuit.
as paid for by the learned advocate for the petitioner, this matter before the next available circuit. Yes, Mr. Thor, you are. Siliguri Municipal Corporation is represented by its learned advocate. Yes, next.
21, your lordship, similar, I'm praying for next circuit, your lordship.
As paid for by the learned advocate for the petition, this matter before the next available circuit.
Grateful, your lordship.
My lord, 22, I am for the petitioner. My lord, this is a transfer matter of a school teacher. My lord, transfer application is pending. Let it be considered, my lord. My transfer application is, my lord, at page number
Who is appearing for the state?
17.
Have you served upon the respondents?
Yes.
Where is the evidence?
Yes.
Sir, service, today course of the day, I'll submit. It's ready all.
You are appearing. Yes.
My lord, page 17 is my transfer application. It is pending, my lord. School already given NOC. My lord, kindly turn page number 20. That NOC part has already completed. Page 20,
Now the
my lord,
DI
school
has
issued the
taken
NOC.
petition.
Yet let it be forwarded by the school to the DI and DI forward to the school service commission. Only that much.
The petitioner who is presently serving as
My lord, Kamath Fulbari, Anga Devi Girls High School.
an assistant teacher in a girls' high school in the district of
Kuchbihar.
the district of Kuch Bihar. has paid for transfer to a school near to her residence. First of the learned advocate appearing for the petitioner submits that the school authority has already given the no objection with regard to the prayer of the petitioner for transfer. First up, he submits that the school authority has not forwarded the application to the DI.
Yeah.
Paragraph, in the light, Mr. Shah Learned advocate appearing for the, art Mr. Shah Learned additional document clear on such submission. First up, paragraph, WPA 739 of 2025 is disposed of by directing the teacher in, by directing the
Head of the institution.
by directing the school
Head of
authority
Yes,
to
yes.
forward the application to the district inspector of schools within bracket AC Kuch Bihar as expeditiously as possible, but positively within a period of 2 weeks from the date of receipt of a copy of this order. First up, the DI within bracket AC Kuch Bihar being the fifth respondent shall consider the said application and take all consequential steps in terms of this order with regard to the prayer for transfer. With the above observations and WPA 7 of 2025 stands dismissed.
One indulgence, one indulgence, Mr. Sunit Kumar Rai is appearing, he is engaged in another court for the school service. His name, can it be possible to record his name?
For the school service commission.
Yes,
Art Mr. Rai, learned advocate for the school service commission.
He just informed me he is on leave.
I'm just giving.
I am giving under.
Granted by the
Lordship, I am extremely grateful.
Yes, unless you file this order will
Yes,
not be
yes, I'm
signed.
giving. Today course of the day.
Yes, next. Yes. Who is appearing? None appears for the petitioner at the time of call. No accommodation has been sought for either. This case will head to the next level circuit bench. Yes, next. For yes.
24 minutes.
Already governed by a special bench order.
How many more matters of this time, Mr. Kundo? This is the last one. All completed. Thank you.
For this
All
circuit.
completed.
For this circuit. Get
He has a bundle more.
No, all
Waiting for the
completed
next
for
circuit.
this circuit bench or entire,
this circuit.
Waiting for the next circuit now.
all right. Disposed of. Yes, next. Yes, call the next matter. 25.
No,
Excuse me. 22.
My lords, I'm for the petitioner. I'm praying for next circuit.
Transfer of gun
The
license.
earlier matter, earlier circuit bench also you have paid for, so you are not willing, I think. So let it go out of the list. What is this matter?
Transfer of gun license.
Transfer of
Arms license, gun.
transfer
Yes.
to whom? From
The-
whom to whom?
From the grandfather to the, grandson.
Application has been made.
Application has been made, it has been
Where is the
rejected.
report of the
Well,
authorities?
It's at page, 16 of them.
16, yes. This is the application. Why to the government leader?
No,
This
this
is
was
the
the
report.
instruction. This was the instruction.
This was
It
the
previous-
instruction.
It was previously, there was a previous round of litigation.
Yes.
Kindly sees the report there. The petitioner has past antecedents also as a criminal matters and all that.
So it was refused. Madam, what is there? Nothing,
My lords, I beg your pardon, my lords.
nothing.
Upon the instruction given by the learned court advocate on record, my lords, I am being for next second minute.
Well, page number 18 also refers to the reports that is.
Yes, sir, I've seen page number 18 prior to page number 16. I've seen that.
Yes.
When this matter is taken up for hearing, the learned advocate appearing for the petitioner prays that this matter be placed before the next circuit bench. So it appears from the order dated March 12, 2025, that a similar prayer was made. So this court therefore finds that the petitioner is not interested to proceed with this petition. In view thereof, let this matter go out of the list. Yes, next.
Your Lordship, item number 26 and 27, I'm led by Mr. Senior Advocate Amlesh Rai. He's on his way, Your Lordship. He's almost reached Jalpaiguri.
Almost reached, all right, passed over.
Your Lordship, kindly fix it at 12 o'clock. Short Passover only, Your Lordship.
26 and 27.
Your
25 and
26, 27.
All right, yes. call
At
next
12.
matter.
Great.
My lord, kindly pass it over for 10 minutes. 10 minutes.
For 10 minutes. You have got the instructions right now.
Yes, yes.
My lord, only I'm praying 10 minutes because I have a flight to catch today, my lord. I would like to finish it today. Only 10 minutes. he
Yes,
should
yes.
come.
All right. Yes.
59.
Yes. My lord. Instruction on the part of the,
And for the statement.
where is Gram Panchayat?
Pradhan is the answering respondent, my lord. Yesterday, Mr. Banerjee appeared on behalf of the Pradhan.
Yes.
I'm going to ask for the take instruction.
Yes. Yes, where is he?
I didn't see him, man.
I've seen him. You have There in the seen? courtroom. Yes, today he is All present. right, catch hold of him, Passover. Next.
Yes, come.
Catch hold of him, bring him. Yes.
Lordship, item number 30 to 40, Mr. Kanodia is appearing, is in another courtroom, Lordship.
Yes.
So
So next
kindly,
circuit.
Lordship, short Passover, Lordship.
All
Kind-
matters cannot be short Passover.
Your Lordship, item number 30 to 40, Your Lordship, I'm praying for a short Passover, Your Lordship. He is engaged in another court, Your Lordship.
Passover.
Kindly allow the Passover.
Next.
Grateful to Your Lordship.
41. 41, yes. 41, yes. Who is for the petitioner?
This matter has already been disposed of.
Disposed of, again it is appearing, why?
By your lordship on 2nd April 2020.
আমার তাহলে দিয়ে দিলেন কেন? Item number 41.
41.
দেখুন নম্বর ঠিক আছে কিনা?
WPS 655. 655. On 2nd April. By my lordship. On the first day of 2nd. Huh? 2025. Oh. Manaka Roy and others.
It's 25. Oh, sorry, order of 2024 has come out. Acha, 655, it has already been disposed of.
655 of 2025 has been disposed of.
You have
By your
the
lordship.
order.
I have a soft copy.
Yes, a soft copy. Oh, this matter was directed to appear, so. All right, Ashok. It appears that the number of the writ petition has been wrongly recorded in the cost list. Instead of ঠিক আছে already instead of WPA 655 of 2024, WPA
correction
655 of 2025 is appearing in the list. Stop. Mr. Pal, you appeared for the petitioner in that matter?
For the state, my lord.
Mr. Pal, honored advocate, appearing for the state submits that WPS 655 of 2025 was disposed of by an order dated
2nd April 2025.
List WPA 655 of 2024 in the next available circuit page. Next, 24 of 2024. So here mistake, other file has come. Yes, next. Forty-two years.
42 Millard, Mr. Banerjee was supposed to inform the court, Millard, who is the telegraph authority.
The district, my instruction is the district magistrate.
Millard, I have some doubts because Millard, I think Millard, all the distribution and transmission licenses themselves are telegraph authority by way of a central government notification.
All right, then I'm speaking in the next circuit.
Well, let them file it by way of a report. By way of a short affidavit, let them file it.
The West Bengal State Electricity Transmission Company Limited is directed to file a report in the form of an affidavit with regard to the issues involved in this petition. Within, yes, how much time? Within 2 weeks?
4 weeks. 4 weeks,
Within a week from date.
Within a week from
Within 2 weeks from date. Establish this matter before the next available circuit petition. Immediately after expiry of the time fixed for filing of such affidavit. Please check up Mr. Ghosh, it cannot be because the licensing company has to take permission from that. So if it is the transmission company itself is the telegraph authority, so it will take permission from that authority itself.
Well, for the purpose of Telegraph Act.
Yes, yes, what is the function of the Telegraph Act in Electricity Act? It is that provisions will be followed for the purpose of drawing or installation of a pole or for drawing overhead or underground.
Whatever.
Only for that, the Telegraph Act is applicable to the provisions of the Electricity Act. Nothing more than that. So here the transmission or the distribution, as the case may be, is a licensed telegraph. Telegraph authority is the district bank. Section 69, 67. And you can also see the, I think, works of licenses.
Yes, I was showing to your lordship clause, section 3, subclause 2 of the, where the
if you
district
read
bank
that, cannot be that complex. There has to be some authority for that. This payment of compensation, removal of these, all have to be decided by the district banks. Can be shifted, will be finding these provisions from one end to the other end. It can be subject to this shifting costing. So all these have to be decided by the district banks. I have also passed a decision on that is with regard to the shifting.
Shifting.
You are on shifting.
No, not shifting. It's laying of a new transmission line.
All right, so the provisions are there with regard to this for the next matter.
Mr. Jana is appearing on Bhatwali Motor.
43, I am for the petitioner. This is my lord the.
Can it be short fast for Mr. Bormon is appearing in this matter, he's on his legs.
So Borman is appeal. What is this matter?
My lord, the claim for higher scale of pay has been rejected only on the ground, my lord, page 40. Your lordship kindly, my lord, this is a case, my lord, exactly covered by the larger bench decisions. My lord, the page 40, paragraph 1, 2, 3, 4th paragraph.
Where is the rejection order?
This is the rejection I am reading, I am placing. My lord, the
No,
only
where is the rejection order? Which order you are challenging?
that is start from page 39. And your lordship just your
What is the
lordship
count of rejection?
just your lordship kindly page 40, 3rd, 4th paragraph. Page 40.
Yes.
Petitioner is working as an assistant teacher in mathematics honors in science and mathematics group of such and such school on 25th July 2011. The petitioner enrolled for pursuing MSc degree in 2015 after the joining. That is correct. After joining, the managing committee of the school by its resolution dated 20th July 2015 allowed the petitioner to take admission in MSc degree and without taking permission from the undersigned. That is correct. I am not taking permission. My lord, what is the larger bench said? Just my lord, since my lord, I have not my lord larger bench copy. Your lordship kindly my lord, turn to page 51. So permission from the managing committee is the sufficient. No reason, no my lord, the permission is required from the DI as per the government order dated 27 November 2007. Your lordship kindly say I am placing this judgment. Why? Exactly case your lordship kindly see larger bench quoted the paragraph my lord, the page 54. Start from page 53, last paragraph. Page 53, last paragraph, your lordship got it?
Sir, Jana, do you have a copy of the larger bench judgment?
No, my lord, that has been
Do you
quoted
have a
by...
copy of the larger bench
Okay, I
judgment?
have.
Yes, yes, your junior is having the copy. Which paragraph? Which paragraph of the larger bench judgment?
(186).
Paragraph 186.
Yes, ma'am. No, 186. No, my lord, the larger 179. Sorry, 179.
Yes, 186 is a different thing
No,
altogether.
no, 179.
Yes.
My lord, may I read it?
Give me a minute. Give me a minute. Paragraph 182.
No, 179.
No, 179. What does it say?
In case of
182.
any conflict, start from my lord, in case of any conflict between the government order.
Yes, yes. Please come to 182.
No, my lord, what I am saying, 179, there are two government orders. One, my lord, the 1595 dated 26 December 2005. Another government order 593 dated 27 November 2007. 26 November 2007, I have to take permission from the DI. 26 December 2005, I have to take permission from the school authority. The larger bench said, since the 27 November 2007 was not in published in the name of the Honorable Governor, so that circular has no existence. Another learned single judge has relied by the 1595, the 26 December, set aside the government order dated 5th September, 27 November 2007, and said that the permission from the school is sufficient. Exactly, I have annexed the order, exactly, my lord, the order passed by the Honorable Singh. That is page 39.
So when you were appointed,
My lord, I was appointed, my lord, the lordship will impugn order, everything has been stated.
this is the date only.
Yes. I was appointed 25th July 2011. My approval page 23. July 2003, serial number 2.
Mr. Jana, if you please come to paragraph 180. Paragraph 180 of the larger bench judgment.
One second. My lord, before that, my lord, I just, my lord, I will come. And your lordship, kindly turn to page 51. 51 of the Honorable Justice Rai Chattopadhyay hold that 593 has no existence. So the permission from the DI is not required. Quoting the paragraph 179. That is paragraph.
Jana, please show me from the larger bench judgment. When you are relying upon the larger bench judgment, please show me from the larger bench judgment with regard to this issue. Because
Yes.
the larger bench judgment, if you please come to paragraph 180, this deals with time of entry prior to 27th of November 2007. Your case is not that.
180.
Yes, paragraph 180. After paragraph 179.
Right of claim higher scale of pay by any teacher with honors graduate degree at the time of entry prior to 27 November 2007.
Paragraph 80, you are not covered because your entry is after 2007. It deals with prior to entry on 27th of November 2007. Please come to the next paragraph.
180.
181.
181. A teacher appointed after promulgation of the Act of 97 would be entitled to higher scale of pay provided he has acquired such qualification in the relevant subject and the staff pattern permits appointment of a teacher with higher qualification. Yes, I am an honors teacher. There is no question of staff pattern. Honors and PG is the same group. And a melody would be entitled higher scale of pay as per the School Service Commission. That is the melody. Settled law. 97.
Next paragraph 182.
182. Requirement of prior permission before introduction of this control of expenditure act would not be rigidly interpreted, particularly when the managing committee has granted permission to the teacher concerned for acquiring higher qualification in the relevant subject without affecting his duty as a teacher of the institution. Exactly, I have taken permission. The district inspector school shall not deny the benefit of higher scale of pay merely on the ground of failure to obtain prior permission if the DI is satisfied that it is within the staff pattern, because the honors of PG and melody within the one group. That is the settle. And melody shall be benefited by the reason of teacher acquiring higher qualification. They are also required to be guided by 735. That is melody amendment of ROPA 98.
This is paragraph 182 is relevant.
Yes.
I told you that, you said no.
179,
When you are pressing 179, I told you 182.
I grateful to your lordship. Grateful to your lordship. Your lordship, kindly, my lord.
Mr. Jana, you are regularly doing this type of matters every day. I am saying 182 without looking. You said no.
Yes, yes. My lord, just now I don't have the copy of the larger decision. Now I have possessed.
Now, so 182 applies.
182 apply.
Yes, thank you.
My lord, deputy to service people.
'94 also.
Exactly content applicable. बोलता हूँ
184 also.
96.
182, 184 also. এটা ধরো খুলে রাখো ডেটগুলো বলতে হবে
The petitioner is working as an assistant teacher in mathematics, an assistant teacher of assistant teacher in science and mathematics group of Mainatali Junior High School since July 25, 2011. At the time of appointment, the petitioner was a honors graduate in mathematics. Petitioner enrolled for pursuing MSc degree course in July 2015. Now, while the petitioner was in service, he enrolled himself for pursuing. He enrolled himself for pursuing MSc degree course in July 2015. The managing committee of the school, by its resolution number 8 dated 28th of July 2015, allowed the petitioner to take admission in MSc degree course. The last date of completion of the examination was September 3, 2017, and the results were published on January 18, 2018. Just a paragraph. It is not in dispute that prior permission from the district inspector of schools was not taken for the purpose of pursuing the MSc degree course. Paragraph. Pursuant to an order dated 7th of January 2025, passed in WPA 257 of 2021, the District Inspector of Schools within bracket AC Jalpaiguri passed an order dated March 26, 2025. By the said order, the prayer of the petitioner for higher scale of pay was rejected by applying clause 3 of GO number 593-EC within bracket B, dated November 27, 2007. Paragraph. Mr. Janal Anir, advocate appearing for the petitioner, submits that the Honorable Larger Bench in a batch of writ petitions. The lead case being WPA 9921 of 2007 in the case of Utpal Kanti Koron versus State of West Bengal and others, held that the government order dated November 27, 2007 cannot have any statutory force. Mr. He submits that the issue as to whether higher scale of pay can be awarded is a teacher has been appointed after the coming into force of the Control and Expenditure Act 2005 was considered by the larger bench. It has been held that such claim cannot be denied merely on the ground of failure to obtain prior permission. Paragraph. Heard the learned advocate for the state on such submission. Paragraph. The Honorable Special Bench in the case of Utpal Kanti Koron Supra held that took note of the admission of the Secretary School Education Department that GO number 593-AC within bracket B dated November 27, 2007 has not been published in the within Kolkata Gazette Extraordinary and accordingly held that the same cannot have any statutory force. In view of the said observation of the Honorable Special Bench, this court holds that the order of the District Inspector of Schools dated March 26, 2023 by placing reliance upon government order dated 593-AC within bracket B dated 27th of November 2007 calls for interference. Paragraph. The Honorable Special Bench observed. Now, the Honorable Special Bench in paragraph 181 of the said decision observed that a teacher appointed after the promulgation of the West Bengal School Service Commission Act 1997 would be entitled to higher scale of pay provided he has acquired such qualification in the relevant subject and the staff pattern permits appointment of a teacher with higher qualification. Paragraph 182 of the said report states that in paragraph 182 of the said reports, it has been held of the said decision. Reported decision of the said decision, it has been held that the requirement of a prior permission before the introduction of the Control of Expenditure Act 2005 would not be rigidly interpreted, particularly when the managing committee has granted permission to the teacher concerned for acquiring higher qualification in the relevant subject without affecting his duties as a teacher in the institution. It was further held that the district inspector of schools shall not deny the benefit of higher scale of pay merely on the ground of failure to obtain prior permission if the DI of schools is satisfied that it is within the staff pattern and the school shall be benefited by the reason of the teacher acquiring higher qualification. It was further held that they are required to be guided by order number 735-AC within bracket S/SP-32/2002 as revised by the circular number 134-AC within bracket S dated November 3, 2004. Thus, it has been thus the Honorable Special Bench laid down a proposition that the district inspector of schools shall not deny the benefit of higher scale of pay merely on the ground of failure to obtain prior permission. So, in the case on hand, it is not in dispute that the managing committee has granted permission to the teacher concerned for acquiring higher qualifications in the relevant subject. Paragraph, the scope of inquiry for the purpose of granting higher scale of pay to the teacher who has acquired higher qualification, who has acquired the postgraduate degree while in service, is that whether the same is within the staff pattern, and also as to whether the school shall be benefited by the reason of the teacher acquiring higher qualification.
181.
This court finds that the district inspector of schools within bracket AC Jalpaiguri took note of the decision of the larger bench, but failed to take note of the observations. Failed to take note of the observations of the larger bench, most particularly in paragraphs 181 and 182 thereof. To stop, in view thereof, for the reasons as aforesaid, this court is inclined to.
We have one submission.
Yes.
After this episode, it was specifically held. Those who have joined the courses for obtaining higher education, they need not require any prior permission.
Yes.
But after this judgment, it has framed certain points.
Who has framed certain points?
In this judgment of the higher bench of 2024 SCC online.
Yes.
It was framed that the enhancement of pay of acquisition of higher qualification during the service career is dependent upon the relevant rules and not a matter of right. And point number which we are relying.
Which paragraph?
Lordship.
Citation, please.
Point number G at page
Paragraph.
paragraph 273.
273.
Lordship. On the basis of above discussion, we answered the reference in the matter following.
Is regarding past graduate.
273 হলো না। Yes, 273.
না, ওটা ওনাদের কি একটা জাজমেন্ট বললো না তাতে রেফারেন্স ওটা বোধহয় অনলাইনে যেটা সাইট হয়েছে
73, the reference is answered accordingly.
Yes, on the basis of the above discussed, we answer the reference in the following manner.
Which paragraph?
Point number G.
Oh, G. Yes.
নো আমাদের এটাতে
Teacher who has partially complete higher education before entering service.
পাস পেজ
No, this is not a case of before entering.
Yes, it is admitted after entering.
After entering,
So
yes.
after entering service, it will be followed by the control order 2005, which speaks.
No, this is before entering. G is before entering, not after entering.
Yes, if he entered this
Yeah,
for obtaining higher education prior to joining.
Yes.
He did not need prior permission.
Yes.
But in the case in hand,
Please come to paragraph 182. Has been made clear.
ক্যাটাগরিটি এটা ফর ফার্স্ট
Paragraph
গ্রাজুয়েট
182.
কে বলুন যেটা ফার্স্ট গ্রাজুয়েটদের জন্য বলেছেন অনার্স গ্রাজুয়েট
272, this is the applicable in case of past graduate teacher. Past graduate teacher after the control of expenditure act would not be entered.
স্যার কোর্স চলছে আপনি একটুখানি
that is yes, that is also considered. That is staff pattern. Whether
Yes,
that
yes.
school
That is
also an
so paragraph 182 says no prior permission. If after the control and expenditure act, and if
that
we,
point was also taken care that whether the school at all requires considering staff pattern.
please wait, I have stopped at that point you have interfered.
And secondly, the prior permission before the introduction of this would was not required at the time. But after 2005, prior permission is mandatory in case of the teachers who have opted for taking the course for higher education after joining.
No. Paragraph 182 says otherwise. Yes,
Staff pattern is separate things.
yes, staff pattern I'm providing for that. You know, is inclined to
Yes,
interfere
staff
with
pattern
the
is
order
order of
issue.
it only.
So accordingly, the order of the school district inspector of schools AC dated 26th of March 2025 is set aside. First of the district inspector of schools, second within bracket AC, Jalpaiguri is directed to consider the matter afresh in the
In consideration, whether the court directed to consider, they have taken.
Mr. Jana, this staff pattern and whether the school shall be benefited, these are factual
I
aspects.
tell you,
which have to be gone
staff
into.
pattern is applicable in case of division of past graduate and.
Mr. Jana, whether let the DI consider that, whether the staff pattern permits, nothing has been said in this order. You know,
I am within the honors and past graduate teacher. You will also kindly see my recommendation.
yes, I follow you. You please satisfy the DI that it is within the staff pattern. Those aspects have not come in the order. How can I go into that issue? You know, in the light of the is considered the matter afresh. In the light of the observations made by the honorable larger bench in paragraph 181 and 182 of the said decision. Let such decision, the district inspector of schools within bracket AC Jalpaiguri is directed to fix a date of hearing and give a reasonable opportunity of hearing to the petitioner or his authorized representative and dispose of the matter afresh by passing a reasoned order in accordance with in the light of the observations made by the honorable special bench.
Just the academic discussion, you will also kindly see 185 paragraph. Just the 185.
Yes, 185.
Paragraph 185.
Yes.
middle portion, the district inspector,
Give me a minute, give me a minute.
page 98, 98 হতে পারে।
98.
Page 98, paragraph 185.
Yes.
Middle portion, the district inspector, your lordship, my lord,
Yes.
the district inspector shall consider such representation on merits. The reasons for denying higher scale of pay would be that already there are sufficient number of teachers having honors/postgraduate degree on the said subject in the institution, and in such circumstances, payment of higher scale of pay would be a burden on the exchequer. The state should have due regard to the fact that a person with higher qualification would be expected to have the better knowledge in the subject, and students are likely to be benefited by reasons of his acquiring such higher qualification. This is the honors/postgraduate. This is the only another group, single group, and another group, my lord, postgraduate. So staff pattern is not applicable in case of honors teacher or postgraduate.
Okay, let him say so. That staff pattern is not applicable. You are entitled to that. Yes.
And
Yes,
one thing, my lord, one thing, my lord, if my lord, DI, my lord, satisfy that, my lord, consequential benefits.
Yes, yes.
Otherwise, my lord,
Yes, in the event the DI decides in favor of the petitioner, all consequential steps shall be taken by the DI.
in accordance with law.
Yes.
Grateful. May I take back the judgment?
Yes. Take it after it is transcribed. Take it.
Lord.
Yes. Yes, call the next matter.
It will be a loss.
This is that case, Milords, SSB matter wherein, Milords, I am challenging the tender. From day one, Milords, I am before my lordship. I have been technically rejected, Milords. The technical rejection, Milords, will find is at page 88.
Yes, Mr. Singhania, you have got instructions. Yes.
The allegation against me, Milords, is of cartel bidding. At page 88, Milords, is my technical rejection.
Yes.
And it says, Milords, it's fairly written down, Milords. It says, as per GME GTC point number 29, only one bid per bidder is allowed. When a bidder submits more than one bid, will cause all the proposals submitted in the particular bid to be disqualified, hence not qualified for the purpose of procurement. There were 4 different bids, not all the bids were for procurement of ration materials for the SSB personnel. My contention, Milords, are 2, and the documents that I would be relying upon, Milords, is if page 141, Milords, happens to be the FSSI certificate. Of my brother. This is the only document of my brother that I have, page 141, Milords.
Yes.
And Milords, my FSSI certificate I am handing over to my lordship. My lordship will note that the premises, because in other certificates, Milord, the premises is not noted. This is a certificate wherein the premises has to be noted, the FSSI certificate. My lordship will take note of the fact that the premises in case of my brother, Milords, is 343/N.
What premises?
From which the business is getting operated.
That.
And the best way, Milords, to judge it is the IP, if the IP address is tracked. Because who have bid together, their IP address would be the same. And Milords will come to a finding that the respondents, the other bidders, they in collusion with my brother, Milords, has used my brother mobile number in the document. I've been supplying the services for 10 years.
Maybe, but this is
And
this is a factual aspect. How can it be decided at this stage now?
no, Milords, all I say is just one paragraph from the writ petition, and then, Milords, I will address my lordship on that.
What is the stage of the financial bid?
Just opened.
Just opened.
That is unfair, Milords. I
No,
was
it's
here
not unfair, my
before
lord.
my lordship since
My lord,
7.
making blank statements won't serve. Before the writ was served by SSB, the technical financial bid was open. My lord,
The
consider.
writ was served on 4th.
My lord, this is a ration provision for the forces that are stationed beyond 7,000 feet in the hills.
No, I am supplying them for 10 years, Milords. I would have supplied for a couple of.
When in the past.
No, this is not a case. This is not a case of cartel bidding, Milords. This, in fact, is a case, Milords, wherein
My lord, we
Progress
have.
cannot be stopped. So the process cannot be stopped because the entire supply will be stopped. In the public interest, that cannot be stopped. No interim order can be decided on affidavits. No interim order.
Lots of,
Because
let,
whether it was a cartel bidding or not, whether there was a relation.
I agree. my lord.
All the
Let
disputed
my
questions
financial
that-
be also be opened. Let my financial also be
This
opened.
has been
belongs to other
rejected at the
bidders.
technical bid.
Yes, as
Why
an
you
interim
are-
measure.
No.
No, if I succeed in the writ petition,
Then
then
what
my
was the purpose for rejecting your technical bid? You will succeed in the
lord,
financial
if,
bid, I am
if,
telling
if,
you.
if I satisfy,
So either you or your brother will succeed in the financial.
then lord, sir, let all the bid be cancelled.
That is
Let my
why-
brother bid also be
because
cancelled.
that is the-
because the provision says
That is
that
why-
all the bids should be cancelled.
So that is why cartel bidding is prohibited.
Cartel bid is prohibited, let it be prohibited for all then. Then the person who has submitted the bid alongside my bid on my mobile number, let his bid also be cancelled.
That is the difference.
It has been cancelled, my lord.
For the
Both are
cancelled.
Both are
They are saying, so let them file affidavit.
Lord, let my financial be
No.
open for the time being, and everything will
After
abide by the
cancellation of technical bid, your financial
everything
bid
shall
cannot
abide by the result of the writ petition. If I succeed, otherwise, Lord, my writ would become infractual.
Why infractions?
Tomorrow they will award the work order. Then where do I stand?
Has to be. Work order has to be issued. Otherwise, this supplies food this is what is the supply for?
Ration material.
Ration material.
Ration for forces stationed beyond 7,000 feet, my lord.
The petitioner has challenged the rejection of the technical bid. So stop. Which page was the rejection?
My lords, the rejection was on. It was on page 88, my lords. Double 80.
It appears from the materials on record that the technical bid of the petitioner was rejected by applying point number 29 of G capital E small m, proper GTC capitals, which provides that one bid per bidder is allowed. It was recorded that when a bidder submits more than one bid, will cause all the proposals submitted in the particular bid to be disqualified. On the basis of such observation, it was observed that the petitioner is not qualified for further process of procurement. So Mr. Learned Advocate appearing for the petitioner submits that the petitioner has not indulged in any cartel bidding. Some interested third parties have used his brother.
Mobile number in collusion.
Has used the mobile number of his brother.
No, mobile number of the petitioner.
Has used
in their documents.
Has used the mobile number of the petitioner in their bid documents. And the petitioner had no knowledge of such fact at the time of submitting his bid. Such being a disputed question of fact cannot be decided at this stage. The tender was for supply of ration items. In view thereof, this court is not inclined to pass any interim order. Let affidavit in opposition be filed within 2 weeks from date. 1 week. Semicolon reply there 2, if any. Be filed within a week thereafter. Parties will be at liberty to pay for inclusion of this matter in the list immediately after expiry of the period. Yes, call the next matter.
My lord, this is that case wherein I missed a counseling opportunity, my lords, and I wanted the respondent to consider whether they can give me another opportunity of counseling.
Counseling, yes.
And then for this full service commission, I am appearing with Mr. Sunil Kumar Roy.
Yes, yes. Have you considered this? Whether he can be allowed to participate in the fifth round
Page
of?
11 of the gazette I handed over to my lordship.
Dr. Patso, have you considered that whether the petitioner can be allowed to participate in the fifth round of counseling?
No, because the rule is very specific that an absentee candidate will not be given a second opportunity.
No, that is against the rule. The gazette notification I handed over to my lordship, my lords.
Where is that?
On the last occasion, my lords, I handed over a gazette notification to my lordship.
Yes.
At page 11, my lords, thereof. Schedule 3, page 11.
Page 11.
Number 9, my lords, point number 9 of the schedule 3.
Yes, point number 9 says
the qualified absentee.
Yes.
No, it's from
last
the beginning.
sentence of
Last
that.
sentence I've read, my lord. That is when I am absent on the second opportunity. And in case the term used is
how do you
yes.
include that?
It starts with the qualified absentee, which is me. I have absented for one occasion. The qualified absentee candidate shall have to exercise option for selection of school to a post of assistant teacher from amongst the residue of the vacancy. If then also I am absent, then the last line will apply. That is my humble submission.
Yes, Dr. Pacho, what is your submission?
My lord, if I understand correctly, my learned friend is showing a notification of 2015.
Yes.
That is his averment, but it is not annexed to the writ. But that is not the relevant rule. The candidate was the petitioner was a candidate of the first state level selection test 2016. The relevant rule is the 2016 rule, which is to be followed.
The exam happened in 2016. The rules were of 2015.
No, the rule is also 2016. I am giving the court the name of the rule.
Where is the
in front of me right now. This rule is. Kindly just give me 1 minute.
No, the exam was conducted in 2015, 16/8/2015. How will 2016?
No, the 2016 rule for upper primary level of teachers.
The exam happens before the rule.
But Dr. Patso, only one thing. This exam was conducted pursuant to a notification of 2015. How can 2016 rules still apply?
Not there.
Exam.
Paragraph 3. How can the 2016 rules apply?
My lord, kindly, may I place? The relevant rule is the West Bengal School Service Commission selection of appointment to the post of teachers for upper primary level of schools rules 2016.
Cannot be, my lord.
The 2015 rule was not followed. He is a candidate. He has applied under these rules. Kindly see his annexures. Kindly see the intimation letter.
Well, the results were published on the exam.
No, Dr. Patso, only one thing. When the notification was published?
On 3rd of June 2015.
Notification was on 3rd of June
September 20, 2016.
No. The notification for this examination, that was 3rd of June 2015. Paragraph 3 of the writ petition.
No. That entire rule notification, everything was set aside. It was not followed. My learned friend is misinformed.
Dr. Patso, will you please come to paragraph 3 of the writ petition.
My lord. Yes.
So this is pursuant to a notification he applied. Pursuant to a notification of 3rd of June 2015.
Yes. My admit card also
This is
says so.
absolutely incorrect. This is absolutely incorrect. The 2015 rule was not followed. Subsequently, the 2016 rule was.
Dr. Patso, when was the notification published for the exam?
The notification was published in September 2016.
Page 24 is my admit card.
Mr. Dr. Patso, please come to page 24.
Admit card.
The admit card.
Teacher is upper primary 2015. Page 24.
No, this is the TET examination.
Yes, I'm saying about the date of the exam. Yes, if the date of the examination is of 2015, pursuant to a notification of June 2015, how can the 2016 rules be applied?
My lord, may I just explain? Kindly see page. My lord, page 23.
Yes, page 23, yes.
This is his online application form for TET examination 2015.
Yes.
There is no dispute with regard to this. He appeared and he became qualified.
Yes.
After that, he participated in the first state level selection test. Kindly see page 25. Online application form for the first state level selection test for recruitment of assistant teachers 2016 in upper primary level of schools. This is the selection process.
Yes. The
And
earlier one is the
the
eligibility.
petitioner participated.
Yes.
This is his online application form. He has not given the second page. In the second page, the date will be mentioned. It must be 2016 September. Sometime 24th or 25th. During that period, he has made this online application.
Yes, yes. Date of publication of results is 14 September 2016.
There also, my lords, in the mark sheet also, it is 2015.
No, no.
Page 20.
Yes, that is the state mark sheet.
Eligibility test. That and the selection, these are the two different things. Teacher eligibility test is to get the person eligible for appearing in the state level selection.
Yes, my lord.
So now your counseling is for the state level selection test. That was in 2016. So the 2016 rules will have to be applied, not the 2015.
Yeah, the 2016 rule is very specific that an absentee candidate will not be given a second opportunity.
Where is the rule?
The rule, I have a copy in front of me right now. In the schedule, I can give the details. In schedule 5 of the 2016 rule.
All right.
I was of the impression now that the 2015 rules.
15 is the teacher eligibility test.
Now I
that
understand.
is only for the purpose of
We will go through the 16
eligible
rules.
for appearing in the
I
selection
understand.
test.
We'll go through the 16 rules.
All right. So next circuit bench.
Next.
After some argument, the learned advocate for the petitioner praised that this matter be placed before the next level of the circuit bench. Paragraph Dr. Patso, learned advocate appearing for the School Service Commission submits that the relevant rule that should be applicable to the case of the petitioner is the rule of 2016 and not the rule of 2015. Such submission of Dr. Patro is placed on record.
Deeply obliged.
I'm obliged.
Yes, next.
Hello, I'm appearing with Mr. Sunit Roy. I'm putting name in the chat.
All right.
Deeply obliged.
Yes.
Item 46.
Yes. Yes, yes, yes.
After, my lord, item 46, my lord.
Yes, yes.
My lord, already my argument is completed, my lord. I'm relying upon that judgment. My lord, my learned senior pen will argue, my lord.
Yes, what do you say to this?
By the time the authority took the decision, he already got the. By the time the decision has been taken, the child already.
So this can be taken into consider. This can be considered.
Lordship. After your lordship ends, he got the judgment.
What can be done? Mr. Chatterjee will not bring these decisions and the court has to provide the decision.
My lord, meaning my incapability, my lord.
Where is the order of rejection?
My lord, that is, my lord. Page 33.
Page 33. Page 33.
And 31 first and second 33.
33 is the last. 13th November 2020.
The prayer of the petitioner for compassionate appointment was rejected by the orders dated 19/12/2023 and 13/1/2024.
1311, my lord.
1311.
Page 34, my lord.
Yes, yes, 13/11/2024. The reasons for rejection was that at the time of death of the father of the petitioner, the petitioner was a minor. Paragraph. The father of the petitioner, namely Dipankar Majumdar. Dipankar Majumdar was a clerk at a high school situated in the as a high school in the district of Jalpaiguri. He died in harness on November 20, 2024, leaving behind him surviving
2014, my lord, 2014.
November 20, 2014, leaving behind him surviving his widow, namely Pompa Majumdar, and the petitioner herein as the only daughter, as the daughter. Paragraph. The petitioner, initially, the mother of the petitioner applied for appointment on compassionate ground. Thereafter, the at the relevant point of time,
52
the
years.
petitioner
Mother was 52 years.
was a minor and the widow was overaged, for which the application for compassionate appointment was filed by the petitioner. Such prayer was rejected on the ground that at the relevant point of time, the petitioner was a minor and also he did not attain the age of majority within a period of 2 years from the date of death of her father. Paragraph. Mr. Chatterjee, learned advocate, appearing for the, I'm putting in your words, Mr. Chatterjee, that you have referred to. Mr. Chatterjee, appearing for the petitioner, places reliance upon a decision of the Honorable Supreme Court in the case of Syed Khadim Hussain versus State of Bihar and others, reported at 2006-9 SCC 195, in support of his contention that at the time of consideration, he crossed 18 years. 18 years, crossing. And submits that if the applicant has crossed the age of 18 years as on the date of consideration of such application, such an application could not have been rejected on the ground that he was a minor at the relevant point of time. First up, paragraph. Heard the learned advocate for the state on such submission. First up. It is not in dispute that at the time when the application for compassionate appointment was considered, the petitioner crossed 18 years. The petitioner had crossed 18 years of age. First up, the Honorable Supreme Court in a more or less identical situation directed consideration of such application for appointment. First up, in view thereof, this court, in view thereof, WPS 722 of 2025 is disposed of by directing the, who will consider?
My lord, first DI and thereafter School Service Commission.
By directing the District Inspector of Schools to
Yes, point number 8.
being the eighth respondent herein to consider the matter afresh in the light of the decision of the Honorable Supreme Court in the case of Syed Khadim Hussain Sipra. First up, for the reasons as aforesaid, the order.
Thereafter, and thereafter communicated
the
the order
reasons
to
as
the
aforesaid, the
West
order
Bengal
dated
Regional
19th
Service
of
Commission.
December 2023 and 13th of November 2024 are set aside and quashed. First up, in the event the District Inspector of Schools decides in favor of the petitioner, consequential steps shall be taken in accordance with law. Yes, Mr. Chatterjee.
My lord, grateful, your lordship.
Yes, all the yes. Mr. Rai, you will be staying back or you will be leaving? You will be leaving your town very early. That is why you are not here. The Honorable Additional Advocate General will remain. Yes, yes.
My lord,
Yes.
this is an adjudication order arising under the GST Act. My lord, I have challenged this adjudication order on 3 grounds. First is, my lord, that the relied upon documents were never given to me, and at least, my lord, 6 requests were made to them. They have noted in their order, in their adjudication order, and said I was playing gimmick and not cooperating with them. And second, my lord, they have clubbed 2017-18 and 18-19, my lord, in the show cause notice and in the adjudication order, my lord, which is not permissible under the act, which I will show, and this has been.
Yes, but the relied upon documents supplied to him.
Your lordship, just today through WhatsApp, I have received the instruction because the today there is a holiday and the concern officer was out of station. Just today, I got the printout from the WhatsApp.
No,
and
whether the relied upon documents was served upon them.
Yes.
Served upon them.
In the instruction, it is mentioned in para number 14 that the relied upon documents were annexed with the show cause notice, show cause cum demand notice, and
let them file a report in the form
which
of
was
affidavit with regard to
Yes, my lord.
because according to them, it has
My
been,
lord, I have.
it has been served.
Madam, if that is so, I think it's better to approach the appellate authority.
No, my lord, let them file on affidavit.
Petitioner has every opportunity to prefer appeal before the appellate
No, my lord,
authority.
if the relied upon documents are not given.
We
to
have
me,
already
I-
served.
It has been given.
No, my lord.
We have
they
already
noted.
served.
My lord, I will, from their own documents, I will show.
Yes.
My lord,
So
they
when
show-
can you file this affidavit?
4 weeks.
Why 4 weeks? You will only
Yes,
say this
at least.
document that it has been served.
And
Yes,
proof of
yes.
Service. my lord.
Moreover,
And the proof of service, it
Yes,
can be
yes.
done within a week. For that, you need not need 4 weeks time.
And my lord,
at
they have
least 2 weeks
admitted.
time is required.
You only the document showing that it has been served. It's a positive statement that it has been served. So show that it was served. Otherwise,
With proof, my lord.
the writ petition is maintainable. If you have served, then
Yes,
they have to be
we have
relegated to
served
the
as per
the petitioner alleges that there has been a failure of principles of natural justice as the relied upon documents have not been served upon the petitioners. First up, Mr. Bonik, learned advocate appealing for the CGST authorities.
Say CGST and DGJ, all the respondents.
For the respondent submits on instructions, submits comma on instructions that all the relied upon documents were served upon the petition. First up, however, no materials have been produced before this court today in support of such contention. First up, which respondent shall file? Which is the concerned respondent?
That is the DGGI.
DGGI, the adjudication.
The respondent authorities are directed to
Respondent authorities.
file a report in the form of an affidavit within a period of 1 week from date, disclosing the materials in support of their contention that the relied upon documents were served upon their petitioner. So list this matter before the next available circuit.
My lord, meanwhile, my lord, no coercive action.
Nothing will happen. Fine.
My lord, may I have?
That is
my-
why I have given
my
a
lord.
short date.
Yes,
1
yes.
week.
My lord, may I get the instructions, my lord? They are saying they have got instructions that.
Let them disclose that instructions. He will give that. It will be said that it has been that I have recorded. Let them disclose the.
Yes, my lord.
Yes.
Yes.
Grateful.
Lordships,
Grateful, my lord, I'm grateful.
Lordship, may I say serial 30 to 40? Lordship, I was there but not added as panelist. I was there, but it was so I couldn't speak.
Yes, Mr. Kanodia, please wait. Yes. Call the other matter. Yes, 11. Yes, Mr. Uday. Yes.
Mr. The demolition order has been, they are enjoying the
Oh, this
demolition
is
order.
this is the extension of interim order.
Yes, Lordship.
Yes.
Without filing the reply to the opposition filed by the corporation.
Yes.
Lordship, interim order passed on 28th January.
Yes, yes. Show me your plan
Yes.
for
Lordship,
construction.
Lordship.
Plan you can show, your senior can come. You can show the plan for the construction.
Lordship, first of all, Lordship, come to the page 52, Lordship.
For arguments, your senior's presence may be necessary. For plan, you can show that.
Lordship, come to the page.
Where is your senior?
His vote number 1.
All right, Passover. Next. Yes. 13, yes. Yes, Mr. Kundu.
Item number 13, my lord, I am for the respondent number 8.
Yes.
Administrative respondent number 8.
I am for the president managing committee.
Yes, what is this matter?
First of all, my lord, I leave to correct the cost title, short cost title, my lord, because my lord, the school name
That
is
leave can be granted. What is the matter on merits?
matter, my lord, the Uday Shankar Chattopadhyay. Uday Shankar Chattopadhyay is appeared.
Where is he? Where is
My lord,
he?
he was present in the previous,
Next circuit.
when the matter.
List this matter before the next available circuit date.
Yes, my lord, Uday Shankar.
My lord, I am for the petitioner.
Yes.
My lord, here in the instant case, my lord, the petitioner before your lordship, my lord, participated in the process of appointment of assistant headmaster, and that was approved by the DI. The panel was approved by the DI, but the joining approval not done by the DI. I made an application.
The DI.
Page 48.
Joining approval letter.
My lord, kindly come to page 48.
What can the appointment of the, I'm sorry. The appointment of the assistant headmaster, starting from the notification, subsequent selection, the entire process is tainted.
But who conducts this selection?
Secretary, Administration, Managing
The
Committee.
school pursuant to 1628 GO, if you kindly.
Yes,
recall,
23,
because
my
it's
lord.
not a
Kindly come to
100%
page 23.
So that the
Page
entire
23.
process was tainted, my lord, it
No, my
suffered from
lord. No, my
expressing
lord. Page
nepotism.
23.
All right, Mr. Chatterjee, this cannot be decided without affidavits.
That's right.
My lord,
That's
Lordship,
right.
Lordship, kindly have a
Because
look into.
we have to
My lord,
disclose the fact of cancellation which they have not challenged.
my lord,
Well,
Lordship,
I am
kindly
for
have a
the
look into.
respondent number 8,
Mr.
the school
Chatterjee, let
authority
them disclose
headmistress.
this. It will be decided.
My lord,
According to you,
kindly.
you are working. If you are entitled to joining letter, it will be from a retrospective effect. If
My
you are
lord, kindly
found
have
that you are working.
My lord, 1 second, my lord, kindly have a look into page 23 and 24.
All right, I will decide
My
that.
lord, notice was given.
All
Total,
right, Mr. Chatterjee, they are saying it has been cancelled.
who are
Let us-
saying, my lord, who?
That will be disclosed in the affidavit, Mr. Chatterjee.
That's
Well, I am for
Who-
the respondent
I don't-
number 8,
my
the
lord, with
headmistress
respect,
was
there is-
taking all sorts of legal formalities. The
There is
panel
no,
was prepared. I have
scope to
sent all
pass
the
any
papers to
interim
the
order
district
at this
inspector
stage.
of school for granting approval.
well, only
As paid for-
consideration order. I am not
of,
paying any order. I am paying for consideration to the DI.
Sound out of the floor. The petitioner has paid for.
My lord, I am paying for
of,
consideration order.
joining approval letter for the post of assistant headmistress at Sunita Bala Sardar Girls.
Suniti Bala, Suniti, that is the correct.
Suniti.
Suniti Bala hai.
Suniti Bala Sardar Girls High School.
Sodor Girl High School.
SADR.
That is also you have said Sardar.
Sodor, SADR.
You have said Sardar.
No, cost
SARDAR.
This is
In
Shodor
the
Girls.
prayer.
Odor, my lord.
Prayer AC.
Sunita Bala.
Sodor Girls High School within bracket 12. Paragraph, Mr. Ghosh, learned advocate appearing for the school authority submits that
School authority, my lord.
Well, I am for the
process
school
of,
headmistress.
appointment of the petitioner to the post of assistant headmistress has been subsequently cancelled. Full stop. There is no scope to pass any interim order at this stage, as the same, comma, if granted, would amount to allowing the writ petition at the stage of
Well, not cancel, my
granting the
lord.
final
Headmis-
relief at the stage of admission.
This is the
Full
reason,
stop.
my lord, that DI could not take any.
Full stop. Paragraph, the learned additional advocate general representing the state submits that in view of the cancellation of the selection process, no steps could be taken, no steps have been taken by the concerned DI. এটা না উপরে লিখে দেবে, তারপরে লিখবে হচ্ছে ওই scope to pass any, ঠিক আছে? So paragraph, let affidavit in opposition be filed within
4 weeks.
Sir, 2
why
weeks,
4
my lord. My lord, 2 weeks, my
You'll
lord.
be getting an entire week holiday. Your
My lord,
juniors
2
will
weeks,
prepare,
my
you will
lord.
not prepare. You have a
My
team
lord,
of
my lord, this is a political game, my lord.
3 weeks.
My lord, 2 weeks, my lord.
3 weeks from date, comma, reply thereto if any be filed within a week thereafter. List this matter.
But the state
No.
is also.
Everyone, 3 weeks.
My lord, what will happen, my lord, unless the Mr. Ghosh discloses, will not be able to, my lord.
All right, Mr. Ghosh, you give a advance copy.
I will. Millard,
Then I will deal with them.
Millard has granted 3 weeks. Within 2 weeks, Millard, I will circulate.
Then, my lord, I will.
My lord, I am appearing on behalf of the respondent number.
4 weeks, 1 week. Parties will be at liberty to mention for inclusion of the matter in the hearing list immediately after expiry of the period is for extension.
Well, I am for the respondent number 8, the headmistress. I shall
Next time
use
when
separate
your lordship
affidavit, my
comes
lord.
Yes, call the next matter. Yes, yes.
26. No, 26.
My lord, I have dreamt yesterday, and Lord Mohavi said, whatever you will ask to the living God, as my lord, all would be reflected today as translated.
Yes. Yes, Mr. Rai.
My lord.
Now, only one thing. I think this is with regard to the failing of check.
Yes, yes.
What is your instructions with regard to
Yes.
the inquiry? Whether
Yes. My lord, kindly take up the, the query from your lordship, whether the notice for suspension, my lord, which is at page.
No, whether the inquiry, you have conducted an inquiry.
My lord.
So whether this inquiry was upon notice and whether the inspection or the inquiry was or They were allowed to participate in the.
My lord,
inquiry.
kindly take up, my lord, the NGT's order.
NGT's order, where is it?
My lord, at page, my lord, 60.
Of the writ petition?
Yes, in the writ petition.
Yes. Yes.
My lord, straightway, my lord, kindly come, my lord, 60,
62, yes.
my lord, paragraph 8. Paragraph 8. my lord.
Yes.
It is further stated in the affidavit that the additional district magistrate and the district land reforms officer Darjeeling had submitted an action taken report on sovereignty garden filling with regard to the letter of the district magistrate and collector dated 6/12/22. In the action taken report, inter alia following aspects have been stated. My lord, it has been said. Now, my lord, in that is A, B, C, D, E, F, G.
Yes, yes. That is the report.
Then, my lord, kindly come H.
H.
H. A, B, C, D, E, F, G, H.
Yes.
The several complaints on tree felling was received.
Yes.
And on 21st April 2022, the tea garden was directed to immediately stop felling of trees. And a detailed report was sought from subdivision officer Miri. So, my lord, in the report, my lord, in the order of the NGT, my lord, it is specifically stated this 21st April 2022 was served and directed the tea garden to stop felling of trees.
No.
I'm coming, your lordship.
Yes. Yes.
Then the subdivisional officer Mirik submitted detailed report 25/4/2022. On
which
next
paragraph?
I.
Oh, yes, yes, yes.
The subdivision officer Mirik submitted detailed report dated 25th April 2022 on the tree felling, stating that around 170 trees had been felled and directed the garden management to stop tree felling immediately. That thereafter subdivisional land reforms officer Mirik was instructed to auction all the trees now. Now, my lord, the first was that it was communicated or not, your lordship's query, that they said they do not know. Then, my lord, from the NGT's order, my lord, it is clear that it
They
has
were,
been
they were party in the NGT.
party. Now, my lord,
Subsequently,
kindly see the order first portion, very peculiar, page 60. Kindly come page 60 once again. This 40, when the final order was passed, my lord, page 60, bottom. For applicant, my lord, none.
Applicant is
None.
yes.
None.
The complainant.
Complainant, none. Then all the respondents were represented.
we are not there. Subsequently implemented. Next page, we have been implemented subsequently. No, I am not going to this question.
Now, my lord, the question is that this NGT order is well in the record, well in the knowledge of the petitioner, my lord. Now, in the writ petition, they have not challenged that the report submitted by the subdivisional land reforms officer or the, my lord, the authority conducted an inquiry without the knowledge or without serving any notice or giving an opportunity of being heard. That has not been challenged in the writ petition. Neither it has been challenged the 21st April 2022's direction that not to filling, not to fell further trees and the auction would be taken place. That has not been challenged. What is the prayer, my lord, in the
Only one thing. He prayed for how many trees shedding off?
515.
500.
515. So this entire 515 has not been paid.
No, my lord, it has fell.
515
Price fell.
515.
Not 186.
So not the
So, my lord,
entire.
this is the
I
so, my lord, this
I
is
just go to the class over.
All
You
right,
say, and I
yes. No, I only wanted to know whether the entire trees permitted to be felled has been felled or not.
no, my lord, kindly,
So at
kindly,
that point of time, it was stopped by virtue of
by
this
virtue
order.
of this order. Now, my lord, the question here, kindly see the prayer of the writ petition.
Yes.
Prayer 20, page 22.
Yes.
Number A1, to forbear from giving effect or further effect, public auction properly held on 30/12/2024. Then, my lord, to allow the petitioner to leave, sell and move these felled trees, logs lying in sovereignty estate, to issue the transit pass and then the PCD. So, my lord, the challenge is here whether these are the trees are shed to, these are the trees are shed trees or not.
Yes, yes.
These are the
Just you see, Raji. Stop.
Yes.
ঠিক আছে দেবো তখন রিজাইন করবো তখন জব করতে দেবো whether the shade trees or not. Now my lord, at the first instance when the committee was constituted, it said that trees are the bushes, tree bushes are beneath the shade trees. And in this code, my lord, the report was submitted. Then the DFO, on the relying on the report, 3 Men's committee's report, forwarded for such granting such permission to the district magistrate. Now district magistrate issued. Thereafter, my lord, it is learned through the social media and the other sources. Then the DFO had caused an inquiry to his officer. Then this report has come that these are not the shade trees. So, my lord, if these are not the shade trees, then the permission cannot be given. And this is the reason, my lord, it was, for the time being, it was directed not to fail further. And as it is in the perishable in nature, those already in the garden, Jimma was given, so auction process was initiated. Now, at this juncture, petitioner was represented before the NGT. The petitioner was represented before the Honorable High Court by way 482 application, my lord. Now, in this writ petition, what they have challenged?
Only the auction.
Auction. So the mother has come, my lord, whether genuinity of the order passed by the district magistrate, whether it falls within the meaning of shade trees, whether the trees were the bushes were there, were under the beneath of the shade trees or not. This my report said no. Then, my lord, he has to review. He hasn't, my lord. So now today he has come because the my lord, kindly see for the benefits of the petitioner, my lord, what we have done for initiating the process for auction. Now the sale process would be reserved, my lord. Last times it was even your lordships, my lord, to some extent a query. The petitioner even did not participate in the auction process. Though wide publications were made in the website as well as, my lord, through the newspaper publications, my lord, they had chosen not to participate. Now, even if the rate which the auction bidder stood highest, not lowest, stood highest, would be would be highest. Yeah. Then
I make it very short. Can you come to page 28 of the writ petition? For a moment.
Let him conclude.
So in these circumstances, my lord, the auction process twice. The first time it could not be because of the, my lord, the ensuing the parliamentary election. Thereafter, second time it has been initiated. Rate has been fixed because by the committee constituted for the West Bengal Forest Development Corporation. Then, my lord, the auctions now is going to lift the, my lord, the producers of the goods. The sale process, after the lifting, the sale process would be deposited in the state exchequer. It would be kept unless the matter is decided whether they are entitled of those trees fallen in the, my lord, within the category of shade trees, then they are entitled. Definitely, it will come by of affidavit, my lord. Suppose now today, what is the purpose they have, my lord, the permission was obtained? Definitely to sell the trees in the market. And through auction process, this is coming. Amount would be reserved. So how the petitioner will be jeopardized? Nothing. No way. So, my lord, at this juncture, my lord, unless it is disclosed, because I said, my lord, within the tea garden area, there is a land classified shown as the forest land. This we will disclose it, my lord. If it is a forest land, this is, my lord, 69. In the NGT's order, my lord, if your lordship see the affidavit of the additional district magistrate, my lord said, the accepting 79 plots, they were allowed to, my lord, for a afforestation for some other plans. So, my lord, these are the things required to be adjudicated, my lord. How the petitioner will be the sufferer at this juncture? Had it been they had challenged the notice long back in 2022, long back the inquiry was conducted, it has never come up before your any court, before or your lordship's court even. We challenge the auction. So, my lord, at this juncture, how it can be, my lord?
Anything more?
No.
No, my lord, can you come to know? Please give lordship and shall I put this question? Can you come to page 28, the permission of the writ petition?
I'm not disputing.
No.
My colleague, the order was passed.
Mr. Rai, only one.
No, only my lord. Whether it is revoked or not. Only question, it is revoked or not.
I'm not on that. Only one thing, that is on merits, only one thing. Now, the
How?
fees have been.
My lord, no. But this order, revocation order has
I
been
will
served
hear
after.
you. I will hear you,
Sorry,
Mr.
sir.
Rai. Only one thing. The fees have been paid, rightly or wrong.
Pardon,
Some
no.
fees, let us
It
assume.
is on my Jimma.
This in your chamber. Now, for what purpose what he will do, let us assume that his order of public auction is set aside. He will sell it in the open market.
My lord, goods is with me. So you also kindly sell for that person be stayed.
He will sell it. What is the purpose of it?
I'll sell it, but the reserve price is given 12 lakhs. They may sell this 4 lakhs, then I'm not profitable, my lord. You also can see. So you also kindly give a, sorry.
Please allow me to
Sorry,
conclude.
sorry, my lord, sorry, very sorry.
So I will sell it. So you are only interested in the value of the goods now. For the purpose. Now, according to you, those were shade trees. Permission was
No,
rightly.
I'm not going to the question. Shed is. There's no shed is
All right.
defined.
All right.
Shed is not defined.
All right.
I'll place my evidence. Kindly allow
Let
me.
us not go to that.
Yes.
You have been granted permission to fell certain trees.
Including Dhupi.
Yes, yes. Certain trees.
Yes.
Including Dhupi and.
That has not been revoked.
Now, according to them, it has been on inquiry, it has been found certain other things, and there was a stop work notice and these things, and public auction was held.
Unless revocation of this order.
Not on merits, that will be decided on merits. Now a public auction has been held. Now, according to them, and highest bidder has been selected.
What is the price?
Your price you are not aware, and your grievance is that also you are not notified, you could not participate in the public auction.
I'll not go because this is my goods. I'll not go.
The right, there are two.
But you will
Whether
appreciate.
it's your goods or not.
Unless this statement is confiscated, can auction it.
The right, this has to be decided at the time of final bid.
But suppose it was sold
Now
in
you are paying
under value. And see the value.
Yes, yes, I appreciate that.
They have reserve value 12 lakhs 90,000.
What is according to you the value?
So they have given the reserve value here, page 28.
Page 28. Yes.
My list of documents I've given to yesterday.
No, I'm asking you, what is their value and what is your value?
This is
what is their value, what is your value?
I cannot assess the value because
why?
But there's no scope of because goods are lying with me for 2022. You can see.
You don't know the value of your goods. Your client must be.
My can see in there at page 28. These are documents you have supplied. My lord, these documents have been supplied by Mr. Chaudhary before lordship. I made the documents. These are documents I placed before lordship.
It has been supplied.
28.
This brief history of and statement of facts.
No. My lord,
No, that is my report, my lord.
From his report, all the documents I have.
You have collected.
Oh, you have collected from his report.
No, I made.
Because I have definitely have rendered you some assistance to you.
Yeah.
Yes.
Can you come to page 28?
28.
The auction 28 and page 25. The reserve price is given 12 lakhs 90.
Yes. 12 lakh 90,800.
Yes, this is the reserve price.
Yes.
But you logically appreciate. I just play some Mr. Chaudhary has argued before lordship. I just from these documents that show one thing, two things, my lord. And see the what's the matter of ID, my lord. Can you? I show.
Very.
Your lordship, can you come to page 4 for a moment?
Page 4
of your document, I mean.
Your document.
This is not my document, your document I just given. I made a list of
now, since you are producing, it's your document.
Yes. No,
yes.
This is my application.
Yes, your application, Mr. Rai, also says shade tree.
Shade tree. Yes, I'm coming to the point of this. I asked for which are giving the shade to the trees. Shade trees are not defined, and I got this. It's a point of law. So, my lord, these are the shade trees. I'm not going to the question. I asked for the filling of the shade trees. Now, your lordship can come to the next page. There's 5.
without definition, how you have asked for?
Yes.
I just, please, Chaudhary.
Yes.
Can come, this is their report. My lord, yes, can see, involved, here the full form in the joint inquiry, a separate list containing the details of trees.
In original.
Or in original. That is not given by Mr. Chaudhary. This is a report. Man, you see that this is an application form, joint inspection inquiry. Separate list attached. Separate list attached. Can you see page 7? 515 number of trees. Purpose of felling trees were given. Now you also can come to, there's no list is given.
Yes, Mr. Chaudhary, there is no list of these trees. It has been
This
said.
Milord, this is here, their list.
Now,
No.
these are your list.
Inquiry. Format of joint inquiry. In the
Yes,
inquiry, you have
yes,
given.
Milord,
Where
that-
is the list?
Yes.
You
That
have
is-
said
that is
separate
my-
list
That
attached.
is my report.
No.
Report in 5.
I'm coming, I want.
My report, kindly come, my
Yes,
report.
your report.
From your report, I take all documents.
From that report page.
Page,
There's no-
Milord,
there's no
5,
president.
5. Page 5.
Yes, page 5.
Lordship got it, page 5.
Yes,
That is the 11/12/2019 letter.
yes,
My lord, in this next page,
yes,
that is the form.
yes.
Now, my lord, that has been filled up by the, my lord, the welfare officer, name of the applicant.
Ye-
Filled up by the name, first column, name of the applicant.
Yes,
The welfare officer sovereignty is there.
yes,
The purpose he has given.
yes.
The list, part B list, it has been attached by him only.
No.
No, my lord, the inquiry, my lord,
This is a form of joint inquiry. How he can give?
my lord, joint inquiry, the list,
By
my lord,
you.
person, name of the applicant, my lord, can you see?
Can you see?
It's the applicant is who has filed this application for paying for partial for failing.
My lord,
This is your signed by 3 authorities.
I am not disputing that the permission was granted, and the DM's, my lord, the order at page 12. DM's order at page 12.
No, Mr. Chaudhary, there are 2 aspects.
The
Let us not go into that. Who has given a list? But you, in your
my lord, that is
this
the
11, 12, what is separate list containing? Whether it's given by him or you, where is that list?
My lord, that is the list we'll find from 12, page 12.
Page 12.
DM's approval.
No.
DM approval, my lord, kindly see
No.
these pieces. These pieces.
No. This list, where is that list? Item
That is,
number
my lord,
4.
that is the list, my lord.
Mr. Chaudhary, please come to 11th of December 2019. This
Yes.
document, page 5.
Yes, my lord.
Point number 1 is filled in form for joint inquiry. That is page 6.
My lord, I understand. My lord, I am not disputing this list even. I am not disputing.
No. Where is that list? Show me that list.
Page number 37. Read actually, my lord.
No.
This is
your
separate
bunch.
list.
Where is the
This is not
bunch
your
in
list.
the inquiry, this list?
Yes, my lord.
This bunch in the inquiry has to be, this list has to be
This
annexed.
is the, definitely this list will be definitely. It is not that it is, because now I said that tentative findings and the documents which was available on the record mill on the very day, first day, I have obtained it. So that is the list of measurement. Now what lordship is asking.
ওটা জিম্বার নাম্বার মেজারমেন্ট
Hey, Rajesh, I know. So now, Milord, these 3 inquiry, the 3 main committee, Milord, initial, this is the initial report, Milord. I'm
Yes.
not disputing that the permission was granted and with regards to the specification of the trees.
Yes.
I'm not disputing.
No. That you have not disputed.
Yes, Milord.
According to you, initially permission was given, thereafter on
As per the
inquiry-
list, Milord.
as per the his permission.
As per this list. Permission was given as per this list, Milord.
Where is that?
Milord, that is missing, but I am not disputing.
No. His permission, please come to page,
Page
4
12.
of your document.
12.
4.
4.
This is his application for permission.
15 number.
515. There is no list.
No.
Here there is no list.
No.
Mr. Chaudhary.
This is a separate list.
That is
In the
where is
inquiry
that?
report, Milord, the separate, the reason, Milord, that's the specification.
made by them.
Specification and the species of the trees. That is, Milord, the separate list data. Milord, kindly see the column tree description. If your lordship is asking, is 11. Point number 11, page 6. Page 6.
No, I'm not asking. Point number 11 of page 6.
Yes, my lord.
Please come to page 5. Page 5 is your forwarding letter
Yes,
along with enclosures.
that is the enclosure 6.
Enclosures,
Enclosure,
item number, kindly see. Number 1 is filled in form for joint inquiry.
my lord.
Please turn over the next page.
Yes, then at,
That is page 6.
yes,
Next, kindly come to point number
Attendance.
2 is attendance.
yes,
Attendance you will
Declaration.
find at page 8.
yes, attendance,
Next 3 is declaration.
yes.
Declaration you will find in page
The
9.
page 9.
Where is 4?
That I am saying.
Separate place.
That
That
4,
is
my
not
lord.
here.
That is 4, my lord. That your lordship will find from page 6. That is, I have not annexed. Definitely.
Where is that here?
My lord, that I have to obtain, my lord.
Yes, because
Yes.
in his application, in Mr. Rai's application,
No
if
list
you have-
were provided.
no list was there.
And I am agreeing. I am no quarrel of that, my lord. He has sought for 515. 3-man inquiry committee found that this is the list of pieces, and accordingly the permission was granted on the basis of this list. I am not disputing. I am not disputing. My disputes arose after the permission was granted. So, my lord, with regards to the list, suppose now, my lord, with regards to the list, as for the time being, my lord, let us assume this list is the culmination of the DM's report, DM's approval. DM's approval.
Where is the DM's approval?
11.
It does not say any specific list. Any list is provided.
My
with the
lord,
DM's approval?
11, my lord, kindly see
Page,
the page 12. Kindly see
Page-
page 12. Page 12, DM approval.
yes.
My lord, see the number of trees, 515.
This is the total number. Mr. Chaudhary.
Kindly see the
See-
species then.
Yes, species has been
Two
mentioned.
piece there.
Total number has been mentioned. Plot numbers have been mentioned.
No problem.
But
Yes.
how many categories of dhupi?
Right.
How many? How many?
How many
trees of
rupee, how
trees?
many, this is not
Nothing
mentioned.
has been mentioned.
No, it has mentioned, but it is not available at this juncture.
Yes, yes. So here also it has not been this James, this order.
Yes.
His number, he
list
was like
is
a
there.
number of trees, my lord.
Even
Yes,
my lord,
even the species has given.
even the my lord, even the DFOs.
No,
property.
I'm asking you,
Miller.
what is the procedure? Let us
Yes.
assume,
Yes. Now,
not in this case.
Yes.
Let us assume the hypothetical case. A
Kindly
person
see, take a
applies-
4A. 4A.
The rules is there. Rules.
Rules.
No, no.
4A is
Is
the permission to be granted.
Yes.
No, how to be granted. Let us suppose an
It's a form.
application
Formation one. I'm showing. Yeah, see that.
in the West Bengal Land Reforms rules.
No, it's a land manual.
Land management manual.
Yes,
আছে?
I brought it. Brought it from Calcutta. I brought it from Calcutta.
Now you are based in Calcutta, what can be done? It's not available in the, don't you have a library in
Yeah,
the
yeah.
Bar Association?
Well,
Yeah.
bar.
Yeah.
I have,
In the bar, my lord.
No,
That-
Bar Association, no
Is the
library.
Not
library
the library was
very
very-
small.
it's an embryonic stage,
Because,
my
because
still.
my lord, all these, my lord, is borne from the subscriptions or the other, my lord, the fees which we receive. Out of the expenditure, less than we purchase a book.
Can you not do anything for this?
Not we have so many proposals. Let us sit. Then definitely
Because it is
Yes.
required.
It is
because
required.
Nowadays,
the secretary now is purchasing all the barracks, so that at least
that is from the fund of the Bar Association.
from the bar also.
That is a different thing altogether. May not be so many members from the
This is
subscription.
difficult.
It may not be possible. So this is to be, something has to be done.
No, my lord, when we will sit, we will do that.
Because the,
And
at
the,
least some basic books have to be there.
My lordship, can we? 115, matter is fixed in Kolkata. My lord, can we?
115 a matter has been fixed.
Yes, Justice Sheena speaks one matter.
so that lunch can be skipped.
So come at 2.
Yes, I'm just coming.
Come at 2.
My lord, can I pray me?
Or Mr. Rai, because this list I think is necessary.
My lord, I
No,
will
sir, you are-
be-
subject of
I- Mr.
action.
I will suggest.
So let's kindly, they will file the evidence on this documents. This is required because what is the shed trees, what the question of felling, these are points of law. So but the timbers lying in your jimma. So by this time, they will not sell it. This is why I only,
Auction has been made. Now
But-
let's see. All right, come at 2 p.m.
yes, yes.
My lord, before your lordship rises, my lord, as my dream would be fulfilled, my lord, only have short one in that case.
Motions, some matters have been
My lord, then,
mentioned.
my lord, I understand, but my lord, I will see, my lord, the event, 7th of April, my lord, the Pharmacy Council has sought for a document.
7th of April.
Last.
Yes.
Sought for a document with regards to the, my lord, the strength of teachers and other staffs, faculties. So then on the basis of the furnishing those documents, the subject to renewal, my lord. And we will not be able to furnish any document as there is no teacher. Then, my lord, as I said, the institute is under the threat. Well, may I suggest for 2 minutes, well, there is an interim order. My lord. What is the interim order? If the appointment was issued, not to give effect. It is not issued, not to give effect further. So, my lord, my lordship for 2 minutes, kindly to some extent modify the interim order.
That is subject to the hearing.
My lord, why I am saying, my lord, because apparently,
the other side is to be
I
heard.
understand. That's why, my lord, can you fix it? Apparently, my lord, prima facie, my lord, this court has no jurisdiction. Even the division bench of this honorable circuit bench has decided on my application in another matter. That is a civil post that is with regards to the homeopathic council, and it is the pharmacy council. It is categorically, my lord, I squarely fall on this, my lord, the decision or observation made by the.
Notify him.
So, my lord, kindly fix it at 3:30 or 4, my lord. Anytime, then I understand, my lord. So, sorry, my lord, but I am helpless, my lord. I am helpless.
Already come at 4.
4. We have filed a can application that annexing that document of 7th April.
7th of April.
That
you served it to them.
I have served.
I got the copy, my lord. Through email, my
Through
lord.
soft, my lord.
You are for the petitioner.
No, my lord, I am for the added respondent who are the successful.
Petitioner has to be served.
Has been
Let
served
the
my lord, through.
application also.
Your interest has been protected by the additional advocate general.
I get to.
So your
So, no, your submission, I am not.
No,
confident.
I'm not.
So, my lord, kindly fix it at 4, my lord. Even without my can application, I have no problem. Can is given to bring to the lordship's notice.
But you give them.
I already served through soft copy, through short version, my lord. Kindly fix it at 4.
Ask your junior to intimate.
I will. अरे बाबा कैन ना लो অসুবিধা কোথায় গ্রেটফুল মেলা
ক্যান চলে আসবে
পুরানা একটু আপনি জানিয়ে দিন The riots of Kalimpong, Sadar and Kashiang subdivision may be allowed to cut not more than one tree. Well, can you mark one, not more than one tree? Whatever the size of the holding, for their domestic use only, with the prior permission, the district, the magistrate officer of the government in this behalf. 2. Applications for permission shall be made to the revenue inspector concerned, who shall personally inspect the holding of the riot to ascertain whether cutting of the tree will adversely affect the soil conservation. Only one tree, Miller. In the area.
No, this is for domestic use.
Yes, Miller. So rule 4A said about the domestic. Now, Miller, the
all right. So let Mr. Rai has come. Let him.
All right.
Then you can give it.
I'll give.
So this was the stopgap arrangement.
Always I act on behalf of the petitioner also to assist Mr. Huh?
Can you see the first? Can you have the rules, man? I'm coming.
Which rules this is?
Oh yeah, what is it? Non-for.
Act 2006.
Yes.
Yes, I was now Miller, I was supposed to play.
Now you also can come to Oswald Trees Protection Non-Forest Act 2006. Also can you come to section 5? Yes. Sorry. Now Oswald Trees Protection it is. Section 5, madam. A competent authority may, on receipt of an application from a person to fell a tree. There's no shade tree is not defined here. There's no provision in the shade, because the shade is here. A fell a tree or otherwise dispose of any tree for such purpose as may be prescribed, and on being satisfied with regard to the legality of documents towards the proof of the ownership or lease of the land on which such tree stands, and after making an inquiry in such manner as may be prescribed, grant permission in writing to fell tree. So, but these are general provisions regarding in the non-forest areas of federal trees. Now, can you come to second provision? Provided further that
yes,
in Sadar subdivision, Kalimpong subdivision, and Kashiang subdivision, district Darjeeling, no such permission shall be required if a riot obtains permission under provision of section 4, capital A, Oswald Land Reforms Act, Rule 474 of the Oswald Land and Land Reforms Manual 1991. So, 474. So here it is admitted within the Sadar subdivision of Darjeeling. So this act is generally applicable. This act by provision has given a curve that regarding in Sadar only by the person of section 4A, the rules 474. But this is the admitted position that for felling, you also can say tree, there's no shade in this act or in the land use manual. Shade tree is not defined anywhere, only tree. Now you also can come to Mr. Chaudhry's documents. Yes, sir. My lord, first my application. Then, my lord, Mr. Chaudhry placed that list of documents, can you see separate list content because this is not here, maybe. Now you also kindly come to who did this? BLRO, range officer. Here I can see page 6, my lord, my list of documents are given.
Your list of documents or Chaudhry's list of documents?
Mr. No, same. I've given the list of documents, can you see?
All right, so page will be the same.
Maybe same.
So I'm looking at Mr. Chaudhry's document. Please refer to the page number.
6.
Otherwise, yes, 6.
Can you see the report? This is form of joint inquiry report.
Yes.
Who are the officers? BLRO, range officers, and member Pradhan or Commissioner of Panchayat. So it's a joint report of BLRO and range officer and the Panchayat under section rule 474, that is section 41. So another second proviso of the Act 2006. So here, my lord, so the list is there, separate list is there. Mr. It may be not with Mr. Chaudhry. So this list, they give the description of lands, of the trees. Now you also can come. Attend declare all thing here. Kindly come. Kindly come to page 10. This is subdivision land and environment officer, PLO of the divisional forest officer, with reference to opposite tree filling case. Enclosed fine here with the following documents for favor of your principal taking this action. Order sheet being number, team and joint entry report detailed filed in the specified format. Attendant report, declaration, list of trees applied for clear. Is got it one? So SDLRO, he forwarded it to the divisional forest officer of the jurisdiction officer, the report. So here also list of trees applied for clearing. Now you also can come to page 11 for divisional forester done. In reference to above and having received the inquiry report of block land and land report officer Mirik and subdivisional land and officer Mirik by substance, find herewith the documents, the original along with form from joint inquiry report accompanied by BLR land reports officer secretary Shorichi Mirik and big officer Mount Puri Range, Russian Forest for felling 515 numbers of trees of various species in the retained area of Shori TS Termini. The marking list, the marking list has been duly checked. Divisional officer himself says the marking list has been duly checked, corrected, tallied by the 3-member committee. Felling order may be endorsed if there is no objection from your end. So, my lord, this joint incident report, a separate list that has been checked by the divisional forest officer. He has tallied. Then, on the basis thereof, my lord, this order was passed by the collector under section 4A. This is next page, my lord. Can you see? Your Lordship has pointed out it that plot numbers are given, number of trees are given, species are also given.
But here, it's for the first time shade trees is being mentioned.
Why, my lord?
In the permission.
Because, well, I listen, shade trees are not defined anywhere. No.
You have applied for felling of shade trees.
Well,
permission is for shade trees.
You also can appreciate. In my garden, if I applied for the felling of my mango trees orchard, if it is not specified, law says trees. Shade trees is not defined under any provision of law. Even the Forest Act, it is not defined, not in the Tea Act also. I checked them. This is a very common language, which are giving the shades to the shade trees. Yes, in that I am so proud. There's one. No, you said. But in our areas, the 5 or 6 times shade trees. In my lord, in the south, there's other shade. So shade trees are my shade trees are divided.
Permission was given for 550 trees,
including dhupi species also.
Yes, species is dhupi, chiloni, and
Shimbul trees.
So the dispute is with regard to dhupi only.
That is from them. We have no dispute because can you come to my lord? Next. Now what happened, my lord? Now my lord, after this you also kindly see one document. Sorry for the read petition because this is not here. And you come to page 30 of the read petition. Sorry, my lord.
Yes.
30 of the read petition chronologically.
Yes, page 30. Yes, page 30. Yes.
Just she said I'm sitting for.
Yes.
My lord, page 30, divisional forester asked the range officer to give the tangent process of the verification. Has you got it, my lord?
Yes.
Now, my lord, next
So
page.
this is the division forest officer.
Yes. What about tangent process? You also can see felling order was passed by the collector. If I move the timbers, I should get the transit passes from the forest.
Transit passes.
Yes, transit passes should be by under overall transit rules
So
is there.
this is for the transit pass.
Yes, yes, yes.
Oh, TP is transit pass.
Transit pass. So, my lord, first felling, then movement for sale or any purpose. So TP is required.
Yes.
That has been given by divisional forest officer at Custom Division. Now, my lord, next.
Divisional forest officer requests the range officer to.
Yes, this is the authority of
Yes.
divisional officer. So, my lord,
TP has been issued.
yes, for some other trees. Before that, my lord, can you see, time was extended. Next,
Yes,
time.
yes,
32, time was extended for felling.
yes.
Now, my lord, this is as per 30, time was extended for 60 days.
Yes.
Now you have to kindly come back to their document.
Yes.
Kindly come to page 14. No, sorry, page 13.
Yes.
With reference to subject, date is 22nd April 2022. With reference to subject matters above, it is hereby informed that the order extending felling permission implementation pure 60 days, by the order you are instructed stop all felling operation in Saudi estate and immediately until further orders. This order was given on 28 April 2022.
28 April 2000. What is the page?
Page 13 of the list of documents. Sorry, list of documents.
The list of documents.
Sorry,
So,
ma'am.
in the list of documents is your document. No, it's the Ms. Chaudhary's document. So, the page number will be telling.
Yes.
Page 13.
Page 13.
Page 13 is a document of the collector.
This is page 18, but my page is 13. I make it chronological. No, I'm not removed. Make the
Give me that page number so that it will be.
page 18. Page 18. I've given the chronological.
Their mind.
You are in habit to say. I also in habit to say. So first he extended the
Yes,
time.
yes,
He first extended the time.
yes.
Then he said to stop. Now
Yes.
when I'm coming, now you also kindly come to next page. It's very vital. Page 14.
Yes.
Now divisional officer wrote to the district magistrate. I just read it. In person of this office order number 14 refers the inquiry the felling operation of the estate was undertaken by committee comprising assistant divisional forest officer Kashyap, range officer Bhavanpuri and beat officer. The inquiry report is acted AI for your personal corporate reserve. The three-man committee constituted by BLO, MIRI, composite of BLO, MIRI, beat officer Bhavanpuri, beat secretary Sholini Gram Panchayat had recommended the felling of shade trees on plot number. But it seems that sufficient information was not furnished in the inquiry report, earlier inquiry report. On field verification, it was found that 253 numbers of dhupi trees of plot number 769 recommended felling are not shade trees. There was no tree bushes present beneath the trees. Since the original trees protection under in the non-forest area Act 6 provides for felling only shade trees. My lord, I asked my landed friend to show any document, any provision of this act that there's only shade trees can be felled under this act. My lord, Division Officer wrote it that since original trees protection conservation in non-forest Act 6 provides for felling of only shade trees, while Section 5 says Section 5 does not say this. Section 5 does not say this. There's no such provision. Well, I have checked that there's no such provision under that Act 2006 that only shade trees can be felled. But this observation is absolutely bad. Now, my lord, you are here to take action for revocation of felling permission in that regard. So, Divisional Forest Officer requests the district magistrate for revocation order on the ground that dhupis are not the shade trees, So it does not fall within the Act 2006. Unless there's shed trees, there's no question of failing under the Act itself. This is my lord his version. And you see, on the entry report is given with this. Kindly come to one relevant part is my lord, come to page 70. And yes, 70. I give it go to this. 70.
17, yes.
So, para 3. Out of about 250 duties, marked with block number 76 are filling and logging 130 number of duties are completed. Also 9 numbers more of duties were failed. Logging of the same has not been done. And this is the part of the report. So now entire dispute is duties. Whether duties is a shed trees or not, I am not going to question. Unless it is a shed trees, it cannot be failed. This is their my lord findings. Now my lord, kindly come to Lord, if you can say on the basis thereof, so my lord, now you can come to sorry in the read petition for a moment. That my management showing for Instagram and page 35. Sorry, in the read petition.
Years.
On the very same day, the range officer intimated the manager solidity said, with reference to subject mentioned above, the understanding is instructed to you that the logs which has been kept inside your tea garden, the said logs handed over to you for Jimma until further investigation completed. Now, my lord, this is Jimma number has been given to our employees at page 36, and the measurement list is given. All the duties, if you want that day, place before lordship, at page 46 is the total volume.
Yes.
It remains in our tier.
Yes.
Then, my lord, in this juncture, the division, the district manager has not yet revoked the order. This is my special. If it is not revoked, it is recommended by the DFO, revoked. Now, my lord, your lordship can come to
Yes.
a criminal case was lodged against us.
Yes.
This is at page 48 of the writ petition.
Yes, this was shown that.
No, I am coming by sequence. Criminal case was lost.
Yes.
After criminal case, that was FIT was given. Then other, what I'm trying to show, my lord. Then one petition was filed before in the
Green Tribunal.
Green Tribunal. Initially, Green Tribunal, your lordship, my knowledge is very clear. In the page 53, the first order. This is a first order regarding failing.
Yes.
Your lordship kindly see. Now your lordship kindly come to next order. This is at page 57. Lordship kindly come to page 57. This is the next order.
Yes.
And come to paragraph 4 at page 58.
Yes.
In the facts and certificate, we consider it appropriate to have response, state original, the chief secretary, the principal conservator forest, original state pollution control board, district magistrate, project manager, will stand increase as a response 1 to 6. The register is right to prepare and official already appeared with the tribunal. Next slide, notice be served on the project of the Solidity Estate.
Yes.
Given. Now it is in our knowledge. Now we also can see next order at page 60.
Final order.
No, the final order. Right, that's it.
Yes.
60. In this order, my can see paragraph 5 is page 61 is very important.
Yes.
The district magistrate Darjeeling, Special Court has filed affidavit dated 9 February 23 stating therein that in a meeting convened by district magistrate Darjeeling was attended by the divisional forester Russia. The divisional forester has submitted a recommendation on points number 1 to 3, which are as under. No further cutting of trees or stopping area at plot number 768 at Manjana may take place, and replantation and stabilization of the area may be done with specific time framed by the tea garden. It was suggested by the NCPF that indigenous species of trees duly prescribed by the forest shall be planted at the same plot where the dhupi trees were well in the ratio of the cost of the project opponent. So they have submitted they asked them as to, my lord, for planting of the saplings of the sub trees. Now you can see you're correct. Now the ultimately this petition at page 66 that we find that since Honorable High Court has already taken cognizance in the matter issued at pure direction, nothing further remains for adjudication in the present original application. The same is accordingly disposed of.
So, what is the order of the High Court? High Court has taken
The CRR.
CRR is pending.
No.
That I have pointed out now, 482.
Yes.
That the honorable court say, go to the IO and place all documents, and then accordingly the IO.
At page 49, my lord.
No, but what happened to this issue of felling? It has not been decided by the.
I challenge it.
How it can?
I challenge.
No, not 482. The Green Tribunal also
No,
nothing.
Relegated to the High Court.
No. Sir, High Court has decided the
High
issue.
Court has intervened.
Not relegated. Said High Court has already decided.
High Court has intervened and decided.
So
correct fact has not been highlighted before the honorable NGT, because the High Court was in scene of only 482, not deciding the.
My lord,
But the fact remains, only one thing, please both of you clarify this. There was an allegation before the Green Tribunal with regard to some illegal felling of trees. So now the Green Tribunal, before the Green Tribunal, it was brought to the notice of the fact that the DM granted permission and a portion of the trees have been felled. And some suggestions were made how to prevent soil erosion, some recommendations were made. And it was said that no further. What has been done, but no further. And with regard to further things, nothing has been said. It says action taken report means that these recommendations and other things, this has been taken place. No further felling, that is also one of the action taken. But what will happen with regard to the trees already felled, nothing has been observed by the.
No, I answered it, my lord.
It was said in the by an affidavit before the NGT that we have initiated the process of auction.
That without revocation.
There in the affidavit.
No. Show me that any finding of the Green Tribunal.
No, there's no finding.
There's no finding on the.
Only all thing has been recorded. Said that
my answer is different. Can you see?
All right. Yes.
My answer is that why Green Tribunal said they had been taken note of by the High Court. Why? The affair was lodged. What is the crux of the allegations? We are felling trees or shade trees or dhupi trees illegally. So a criminal case is initiated. The Honorable High Court in the 482, in the 482 jurisdiction, direct us to produce the documents to the IO. If he is satisfied, he will file the FRT. We have produced all the documents, the order. So FRT has been filed. So with regard to felling of illegally felling of trees, this issue also brought to subsequently before the tribunal. So basic issue is felling of trees, legally or illegally. Not shade trees, felling of trees. It's a repeated felling of trees in the tea garden, none in the forest or tea garden. So tribunal said when this issue has already dealt with and decided by High Court, they will not touch it. But they have taken note of that, the recommendation of the that committee, district magistrate, and what I'm trying to submit, in anywhere, they can't produce the order of the DM that for permission has been revoked. No, anywhere. First. Second, my lord, you also can come to.
Give me a minute, sir. Yes, yes.
Now you also can see. So then we applied with them. So my learned friend said,
before?
Them to, after tribunal's order, we applied to allow us to lift it. Not only that, we applied before everybody. In response to that, what DIV has done? This final you also can see. You will also kindly come to page 82. Sorry, first 80. After tribunal's order, we applied for allowed to us leave because it is in our Jimma. Page 80.
Yes, then you applied for lifting of those failed laws.
Because there's a tribunal, criminal case was, tribunals did not touch, this is our order, it has not been revoked by the DM. Then DFO asked us to comply with the para 2. And on 19 January 2024, you also can appreciate.
Yes, 19 January 2024, yes.
He said, he has not said, yes, I inquired, it is revoked, you can't. He said, you have to comply with this. Next, can you see page 82? Page 82. Again, on first, again, February 24, he said,
same thing.
Same thing. Now, I need to see our letter at page 84. Have received your letter, and I am requested submit compensable based on given by the committee by the Honorable National Guild. I have included that 31st March. I have granted for 400 rupees.
So where, which page?
At page 84.
84.
After in compliance with the order or direction of the DFO, we have complied with.
Yes.
This is on 1st April 2024.
Yes.
So my first issue, first point is that there is no revocation of the permission. Secondly, after tribunal's order, DFO asked us to comply with the directions. We have complied. They have not disputed it. They have not, no, your compliance is not correct. It's not disputed it.
Yes.
In contrary to that, they came to know that they are going to, I'll come to
auction.
Auction, no. First, they're twice. Can you see? Can you cast page 85? No, I'm coming. Can you,
Page
85.
85, yes.
3rd April 2024, auction is fixed. What are goods which are in my Jimma? These are my all goods. I wrote immediate letter to the DM. I wrote immediate letter to the DM. At page 86. These are all dubities which are failed, which are lying in our Jimma.
Yes.
Now, my lord, we wrote to the DM, page 86.
So what is the reason for this public auction?
I don't know. This is the, and what public? This is a misplaced of public office, my lord. I said it's a misplaced of public office. I'll show why. It's a misplaced. My lord, I on point of law, I'll argue before lordship. Then at page 86, I wrote to the DM. Next day, my lord, it was stopped. On page 91, it was stopped.
Page 91.
Yes.
Yes, it was stopped, then again it was issued.
Then, my lord, we are waiting for, we came to from the office of the SDO Mirik, I've studied a petition, that they already auctioned it. But this is the issue. Now, I'm coming to the point of law.
So what they have said in that report with regard to this auction, what is the reasoning for holding auction? What is the ground for holding auction?
Nothing. What is authority? My lord, in my writ petition, yes, if you also can allow me, I just taken some point. It was, can come page 15. I raised some issues.
Page 15.
Yes. How under what provision of law he conducted the public auction for sale of those felled trees lying at the Shori DS? Is it permissible to sell those felled trees which are not vested to and property of the state government? Whether such public auction held for sale properties felled trees is arbitrarily illegal or unfair or not? Whether the SDO can sell those felled trees in Shori DS by public without giving any prior intimation opposite to hearing of the petitioner? Whether while the collector testimonies gave permission of felling those trees.
Correct.
But now
these are the points which you have raised in support of your contention that public auction could not be.
Now, my lord, I answer the point of law. What is the point? People can take the law, but they said Dhupi trees, although they themselves given the permission from the list. Now they say point of law, Dhupi trees does not shed trees. So only shade trees can be felled in under the Act 2006. Now, before that, we have these out.
Mr. Rai, those are to be decided at the time of.
Yours, I 2 points I finished. In the lease deed, this is a lease out land. Can you see?
Lease deed?
Yes.
What do you want to show from the lease deed?
Can see 6. These are state.
You have got. Your lease deed.
This is my lease deed. I am the owner of this land. We'll remove that.
Yes, yes.
6E. 6E.
6.
Cause E. The lease shall not, shall not fell trees. Got it, man? E.
6E, yes.
That the lessee shall not fell trees in land comprised in a forest in a tea garden without prior permission of state government. But if so required by the state government, shall submit a plan for maintenance and felling of trees. It is not prohibited. So in the tea garden, even the forest area, there is trees, it can be permitted under what provisional law? Under section 206, read it. Now, I just show one thing. Divisional forest officer raised the issue that only shade trees can be felled. My landowner, I request my to satisfy your lordship, whether law says so or not. Section 5 is very clear. Apart from this, my lord, I show other things. My lord, if can act itself, my lord, can come to the act.
Yes.
Can come to section 21 of the act. Exemption, it got it, man?
Yes.
That
is the power of the government.
I show why. What is subject to such condition as may be imposed the state government in this consider necessary to so do in public interest by notification official gazette, exempt any area or any species of tree or any specified number of trees of any species for all or any other provision of this act.
Yes.
Now can we come to next page schedule? My lord, where has he has not been exempted?
Oh, I could not follow.
What am I trying to say?
So from the schedule, what did you say?
Under the provisions of section 5, any trees can be felled
And there is a power of the government to exempt any nature of the tree or
No,
any area
what I'm trying
from
to
the
say.
provisions of this.
But
act. No, what is the next submission which you have?
I'm just,
That I could not.
I'm just. Oh, no, not in the list. But but in general terms,
According to you, Thupi is not in this list.
yes. But can you see what I'm trying to submit? In section 5, the trees are in general terms. Trees are in general terms. So shade trees not defined anywhere. My landlord, I just recommend to, I write me, this is shade trees are defined in the act or not. Secondly, my lord,
So according to you,
section 21, they can exempt. These are the exempted.
sir, not the exempted.
Mandatory,
Yes, permission mandatory for felling.
yes, this is my Dhupi. If what I'm trying to submit, my son, what I'm trying to submit, that Dhupi falls to the general terms of tree. Section 21 has given the power of the state government to exempt some pieces
Yes.
from mandatory for permission mandatory of felling for felling. These lists are given here. Dhupi is not included.
Yes.
So section 5, my lord, operates in respect of Dhupi.
So according to you, these type of trees are exempt from permission.
No, mandatory. No, this is not my submission is that section
This
5
type of trees,
permission mandatory for felling.
yes,
Permission is mandatory for these trees are mandatory.
others are exempt.
Can see can Khoyar,
So
Shimu
others are exempt.
exempted. Those are coming under section 5.
No one.
Section. Well,
The interpretation according to his own.
this is not a Mr. Chaudhary. I may be wrong, but I'm trying to say. No. Can you come to section 5 for a moment, madam? Again, madam, can you come?
No. Mr. Rai,
I'm just
the other way around. Yes, see. Section 21, subsection 1 says that it's the power of the government to exempt. Even if there is a power of the government to exempt, kindly come to subsection 2 of section 21.
Yes.
Notwithstanding anything contained in subsection 1, that means even if the government has the power to exempt, the permission of competent authority shall be obtained for felling of trees specified in the schedule.
This is I'm trying to submit.
That means in respect of these trees, the government or in the other words cannot exempt these type of trees from the purview
Yes,
of
but
section 21(1).
Yeah, but Dhupi is not there.
Dhupi, the government may exempt, but there is no notification exempt.
No, I'm not.
There is no
No.
notification exempt.
Yeah.
Mr. Rai, let us.
Can you allow me just a minute? You also can come to the formal preamble of that.
Yes.
To an act to encourage and promote plantation of trees and to protect and conserve trees, particularly those looked upon a sacred crops in the endeavor as they belonging to an endangered species and given the same of heritage in the mind that the trees have great environmental value and area a renewable sources. This is the basic object of the act.
Plantation.
Now,
Plantation, conserve trees.
To prevent the felling of trees
Yes,
in non-forest areas.
Yes.
This is not the forest areas. This is not the next. The basic object is to not to fell the trees in non-forest areas without one. Now can come to section 5 for a moment. I'm sorry, but I just repeat it. Section 5 says a company authority may on receipt of an application of a person to fell a tree.
Yes.
Can you see trees? Tree is not defined here.
Yes, I follow your argument. So that's shade tree, it is not shade tree. So any type of tree. So Dhupi is also a type of tree for which permission can be granted.
Can you section 3(9), my lord, for a moment?
3(9).
Tree has the same meaning as in Indian Forest Act 1927 and includes any woody plant whose branches spring from area supported upon trunk or body. So it is in general terms is given.
Yes.
So shade is not defined here. So divisional forester has made a wrong statement, the main observation that only shade is can be.
Yes.
Section 5 give the in general term. What I'm trying to submit, my lord, I can place before lordship. 21, I just placed 21 first. So, I'm sorry.
Section 21, yes.
Six months. So 5 is a general term, the general way, subject to such conditions. If any as may be imposed, the state government may, if it consent is to do public interest by notifying official gazette, exempt any area or any species of tree or specified number of trees of any species from all any other provision of this act. So the section 20 says state government can exempt any trees or any trees from application of this act. My lord, this is very clear. Section 2 says then it's type of proviso. Notwithstanding anything contained in this section 1, the permission of competent authority shall be obtained.
It's not proviso.
No, it says
It has a, 2 has an overriding effect over 1.
1. Yes. No, my lord,
Non-obstante clause.
So
It has an overriding effect.
subsection.
Even what has been stated in subsection 1.
Even I just
override.
your lordship, suppose state government has a right to exempt species,
But in respect of this, permission has
but
to
can be given. This
permission has to be obtained.
obtained. Yes, what I'm trying to submit. Subsection 1 says.
No, I follow your argument. According to you, Thupi is not included in this category.
Even that this.
So that the government has the power to exempt.
Yes.
But here there is no notification exempting Thupi.
No, I'm not going to. Not.
So let us not go into that.
What I'm trying to submit. Those trees, one can see what are the species are mandatory because those are khoyan, shimul, shishu. So Thupi is not that type of curve.
I follow your argument. Thupi is not that power to exempt is there.
Yes.
Power to exempt is there.
The shade is not set.
But here we need not go that far because
I'm trying to submit.
It's a case that you have obtained permission. It's not a case. It's not your case that you are not required to take permission. You have obtained permission. That is your specific
No, I'm trying to
case.
say that they said Thupi.
Let us not go to that far.
Yes.
A case where you have not obtained permission for Thupi, this argument we may consider. In this matter, we did
In
not
advance,
go
because I'm very scared of Mr. Chaudhary.
Yes, anything more?
No.
So according to you, the legality of the public auction, you have challenged on those grounds which I have mentioned. And according to you, we have obtained permission and that permission is yet to be revoked.
I should argue, my lord. Suppose in our tea gardens, they have leased out because my superior landlord.
He is the owner.
I've been, suppose I'm not going, some other dupities are in the tea garden. I ask them to fill it. I ask for permission, not set trees. I have not been allowed or I've been allowed. My lord, when you do the state owned property, that should be confiscated. This Indian Forest Act says, and see my lord, Indian Forest Act, this is a specific provision. I have to put it.
Yes, for that I wanted to know, please, yes, my lord, what is the necessity of public auction?
My lord, now, yes. My lord,
though you have not filed any affidavit with regard to that.
I
only want
your
to know.
lordship has seen all the documents.
Yes.
I will not go into that, I will not give you further trouble.
Only one, please clarify this aspect.
I will clarify, definitely your lordship's query, I will clarify. Before that, kindly, my lord, take up the section 4A and the rules framed thereafter.
4A of this act, 2006 act.
No, my lord, the
4A,
50.
sorry, Land Reforms Act. Land Reforms Act.
Rules, my lord, can you see the rules, manual?
Yes.
Straight away, kind of, because I'll shorten the, my lord.
474.
My lord, these, yes, 474.
Yes.
474.
Yes.
My lord, sorry.
Yes.
474. So 474, my lord, the cutting of trees, any trees, whatever my learned friend said, in Kachiang, Kalimpong, Sodor subdivision, in the district Darjeeling, will be regulated by the rules of Appendix 7. So, my lord, if the section 4A is applicable and applied herein, then it will be governed by the section rule Appendix 7. Kindly come the Appendix 7.
Yes.
My lord, may I read you whole? Then, my lord, how 2006 Act would be applicable. Now, these are the rules relating to the cutting of trees in the Kalimpong, such and such district Darjeeling.
Yes.
Riots of Kalimpong Sadar and Kashiang subdivision may be allowed to cut not more than 1 tree. Only the permission given under rule appendix 7 will not only 1 tree. It's written. I'm coming, domestic purpose. Yes. Whatever the size of the holding or their domestic, only use the prior permission of the district judge. Sorry, the district magistrate. Then will not the 2. I will not read the previous lines, last 3 lines, madam. Adversely affected if the tree is cut and if it is and if it is necessary at all to cut the tree for domestic use by the riot, cutting of trees for sale should not be allowed. Then will the SD or BRO how they will process. Now will kindly see the 2006 Act.
Yes.
2006 Act. Act has come into effect from 2006. Now, my lord, straightway kindly see the section 5.
Yes.
Which my learned friend, my learned senior friend was banking on the proviso. So, my lord, first let me read the 5.1a.
Yes, according to you, 4A will be governed by 474 and appendix 7.
No. 5.1a
Yes.
is a competent authority.
Yes.
I may read for 2 minutes. May on receipt of an application from a person to fell tree or otherwise dispose of any tree for such purpose as may be prescribed, and on being satisfied with regard to the legality of the documents, the proof of ownership leaves such and such, the tree stands, and after making the inquiry in such manner as may be prescribed, grant permission in writing to fell tree below. When there is a provision provided further in the Sadar Kalimpong subdivision, Kashiang, Darjeeling, a riot obtains permission already, then this Act of 2006 will not be applicable. This is the Act said. But which I have shown, the Land Reforms Act and the rules and manual of 474 say if the permission can be given only 1 tree. Here my learned friend clients obtained a permission under the Acts of Land Reforms, invoking 474 manual for more than 1 tree, that is 574. If it has to be invoked, then Act of 2006 will come into play, and Act of 2006 is a competent authority, the DFO. My notification kindness. This is the power which has been vested.
Which notification?
I am handing over. Because that was my second follow argument. I kept it reserved that I will disclose in my affidavit. The notification said the exercise power such and such West Bengal Trees Protection Non-Forest Act 2006. The governor is placed to hereby appoint competent authority, Malad.
Yes.
The competent authority said forest range officer, divisional forest officer, Malad. So, Malad, in view of 2006 notification, Malad, Act, I'm sorry, Malad, if you lordship see the 5.1a to decide, Malad, forget about the shade tree or anything, Malad. Any trees, I'm not going into that. Any trees more than 1 has to be governed by Act of 2006.
So according to you, the district magistrate or the collector is not the authority.
Then next
so
page.
It is only...
my notification on next page.
Yes.
It has come, Malad also got it. It has come from the, kindly see the date 2007, Malad.
Yes.
From the CCA, Conservator of Forest, he written to the Divisional Forest Officer, Darjeeling, Kashiang, all below. Now subject is written procedure of felling of trees outside the forest area. Malad, what said? Since the rules related to West Bengal Trees Act 2006 have already been notified, you are requested not to give any effect to the guidelines issued by the actual district magistrate collector or Darjeeling site quoted above. So, Malad, the additional district magistrates that has invoked, or the collector has invoked the provision of Malad, the 4A with regards to, my lord, the felling of trees. That the power invoking this chapter 7 of the manual, where the manual said not more than 1 tree, and that is to be used for the domestic purposes. That the inquiry to be done by the first the BLLRO, then SDLRO, then the permission would be given by the SDO. This act, my lord, can come back the provision of Appendix 7. Appendix 7.
Yes.
Now, Appendix 7, my lord, the 3. Lordship got it? 3, 1 and 2 I showed. For domestic purpose, 2 is domestic purpose, 1 is more than 1, not more than 1. Then the 3 say the revenue inspector shall send a report personally to the BLRO. Then BLRO shall forward with the remark to the SDLRO. Then SDLRO, after convincing himself of the domestic need of the riot, and if cutting of the trees does not adversely affect soil conservation and public easement rights of such and such, seek the approval of the SDO. Subdivision officer shall have the power to veto the cutting of trees in any individual case or any particular case reason to be recorded in writing. Then 8, while granting permission, the SDO shall stipulate the number and the species sampling suitable for the locality to be planted by the riot within a month of cutting of tree. Then is the afforestation for the for if the tree is uprooted, then these are the trees to be planted. So when the approved authority under the rule 27 is, my lord, the SDO, following the due process of law, not more than 1 tree. Where in 2006 Act, my learned senior friend is banking on that already I have obtained permission under the
according to you, that permission is honest in the eye of.
This is the reason the moment the DFO has seen, this is the reason for the report. May I again indicate the report? That factual aspect has not been brought to the notice of the collector, and some misinformation was given. This is the reason, my lord. This is the reason the DFO say, as it is a your lordship's query, as it is a perishable goods, so for a preservation immediately it should go for a auction sale.
Mr. Chaudhary, one thing. Let us suppose the permission in a case, permission has been validly obtained for felling the trees. Then whether in that case public auction can be.
No.
So public auction is on the ground, according to you, that the permission was not validly obtained. So for that, public auction is being held, because in order to decide that, it may take some time. It's a perishable goods, auction amount to be secured. But if the goods belongs to, upon a decision, it appears that the goods or Mr. Rai's client is the owner of the goods.
He will get back. He will
public
get back
auction,
the money.
no, that is the thing. So public
But
auction
if
is
it-
only
if it's
on a.
not public auction, my lord, then what will happen? He will get back the, my lord, dust, wood
No,
dust.
no. That is a different thing altogether. So public auction is, the foundation of the public auction is that he did something wrong, obtained permission by misrepresenting
Or
and
whatever.
whatever ground, or there is a serious dispute as to whether he is entitled to those goods or not. And some time is necessary to, in order to decide that dispute, in order to preserve the property, public auction.
Right?
Anything more?
No. Then, my lord, this is the reason, my lord, the thupi, as per the schedule of 2006, do not fall. This is the reason affidavit was given with the entity that no further filling of trees in plot number 279.
No further.
No further. Already the fees fell. Now, my lord, why it is said thupi? Because specific, my lord, the schedule is given. Under Act of 2006, the competent authority DFO can validate such permission with regards to the specified schedule, not beyond that. If it has to go beyond that, then the permission has to be obtained for the government for filling of such trees, such as dhupi and other categories of trees. This is the reason, my lord, we have this DFO has the strong objection. Dhupi either do not fall 2006 Act, not even the permission obtained by rightly in view of Act of 2006. The 4A is not applicable, my lord. My lord, kindly look.
Only one thing, where is that document where the DFO recommended revocation of this? No, recommended revocation of these permissions.
Yes, my lord.
Which
My-
page?
my report.
Yes, your report,
Page number 40, 1-4.
1-4.
Yes. Hence, Lordship got it? 1/6/2022. Page 14, 1/6/2022.
Yes, I've got.
1/6/22. Last paragraph.
Yes.
Hence, you are requested to take necessary action for revocation of filling permission in these regards. A decision may also be taken at the earliest.
All right. I've got that.
Well,
Again, reply to reply.
What reply?
No, just.
List has already come to my end, my lord. List, which your lordship was looking for. The list is already come. I have obtained. Well, all documents are lying with us.
My first.
And we will discuss
my
everything we are
I asked my understanding.
Yes, grateful, man.
I asked two things, man. The second proviso of the second proviso act, section 5 has been, you know, by this notification, second proviso has been, my lord, become redundant. This is my first question. Second question, my lord, if
All these legal issues are to be gone into.
my lord, no,
So,
he
reserve
said,
your energy,
no,
Mr. Rai,
no,
at
second
this
question, my
time of
lord, he is the company of the, why he has asked the DM to consider for revocation. Third, my lord, page 80, why he asked me to comply with this, but this.
খুব trouble দিয়েছে।
সাহায্য আমার trouble.
আরে, আমি সাহায্য করতে পারছি। আমি তোমার ভাই, না, না, আমার
The state of West Bengal leaves doubt.
এটা শুনি ওর।
335 point. It is the case of the petitioner. It is the case of the petitioner that the state of West Bengal leased out 335.75 acres of land comprised in Shorey Tea Garden in favor of Messrs. Shorey Plantations Private Limited by execution of a lease deed dated April 20, 2000. Petitioner applied for permission for felling 515 numbers of shade trees in the retained area of Shorini Tea Estate. Please, both of you correct me
Yes,
if
this is
there's
the reason why I am hearing.
any factual error. You can take your seat.
Yes.
The collected district Darjeeling granted permission to fell. What is the page number? I will give you trouble. If you got-
At least 28 or 80.
My report anything.
The collected district Darjeeling by an order dated February 14, 2020 accorded permission in favor of the petitioner for felling 515 number of trees in plot
Shade tree.
here it has not been made shade.
DM said shade tree.
No, number of trees is 550. Here shade trees has not been said.
No, said by.
Said.
Where?
DM
Maybe of 515 numbers of shade trees.
কি বললাম? 550 number of shade trees
Of various species.
Yes.
of various species in plot numbers 769, 1773, 1774, 17 and 1773. Under Khotian number 2 within Moja, Sourini, Sourenee, Basti, Busty.
Species are given by.
And no, full stop. The species of this aforesaid trees has also been mentioned in the said order to be of Thupi, Chiloni, Chiloni, and Shimul, Shimul, Species, Peases. The said permission was valid for us for a specific period of time as indicated in the said order. Petitioner prayed for extension of time for felling of such trees
COVID pandemic.
on account of COVID pandemic. Such prayer of the petitioner was allowed by a order dated, where is the
Page 34.
page 34? This permission extension was given by the district forest officer, divisional forest officer,
Yes, sir. Yes, sir.
but the initial permission was by the collector.
Correct.
All right. কি বললাম? So extension was not by the collector, it's by the divisional forest.
Yes,
TP was granted.
Because the TP was granted.
yes,
আচ্ছা তার আগে না এটার আগে না একটা সেন্টেন্স দেখি যেখানটা পারমিশনটা বললাম না কালেক্টর, তারপরে the petitioner prayed for issuance of transit permit for transit permit before the divisional forest officer, Kashyang division, and such officer directed the range officer Mama Pokhri range. Mamon. Mama Pokhri, it has been said. Page 30. Mama Pokhri range.
I do not, I always say Mama.
Mama Pokhri range to issue the transit permit in favor of the manager Sourini Tea Estate for felling of the aforesaid 550 number of trees, shade trees. The petitioner subsequently no, আগেরটা কেটে এবার পরপর লেখো, আগের যে লাইনটা লিখেছিলাম না, prayed for extension of time, দুইটাকে কেটে দাও পরপর। The petitioner prayed for extension of time on account of COVID pandemic, and the divisional forest officer by an order dated 16th of March 2022 granted extension of time limit till granted extension of time by 60 days and further indicating that no further extension will be entertained. Paragraph. Thereafter, the range officer served a served an intimation for Jimmanama by a letter dated April 22, 2022, directing the petitioner directing the petitioner, instructing the petitioner that the logs which have been kept inside the tea garden has been handed over to the manager of the tea estate for Jimma until further investigation is completed. In the meantime, a complaint was lodged against the petitioner, alleging that there has been illegal felling of trees in the tea garden, and acting on the basis of such complaint, an FIR was registered. Petitioner challenged the initiation of the criminal proceedings by you have prayed for quashing. The petitioner prayed for quashing of the first information report by filing a criminal revision application being CRR 133 of 2022 before this honorable court, and a coordinate bench by judgment dated June 23, 2022. Directed the petitioner to produce all the documents of permission to the investigating officer of the case within the time limit mentioned in the said order. And if on the basis of the said order it was found that the petitioners are entitled to cut the trees in accordance with law, the final report in respect of Mirik Police Station case number 19/2022 dated April 24, 2022 shall be filed without harassing the petitioner in any manner in accordance with law. Thereafter, the GR case number 52 of 2022 was dropped on the basis of the report of the investigating officer. One, Bharat Prakash Rai lodged a complaint before the National Green Tribunal Principal Bench, alleging, complaining about mass tree felling in Shorini Tea Garden. Such application was registered as original application number 576 of 2022. The Learned Tribunal by an order dated December 21, 2022.
I'll get an order. 7th September is order.
No, first please.
7th September.
7th September, I think. 7th September, you did not appear. 21st December, you are direct. The Learned Tribunal by an order dated December 21, 2022. Directed the project proponent, namely Messrs. Tourini Tea Estate, to be impleaded as respondents, to be impleaded in the category of respondent. Paragraph. Before the learned Green Tribunal, the district magistrate filed an affidavit dated 9th of February 2023. Wherein it was stated, and in such affidavit, the recommendations were the recommendations made were highlighted. Before the learned tribunal, the divisional forest officer suggested that in order to control soil erosion and stabilize landslides, landslip, as well as to facilitate restoration of ecology and habitat in the hill slopes and high slope gradient area, no trees shall be cut further in plot number 769. And permission for felling only shade trees in plot numbers 1773, 1774 and 1775 near Monju Park may be granted through District Magistrate, Darjeeling, if found satisfactory after re-evaluating the existing field situation. The learned tribunal after taking note of the
You guys can don't take note of this one also. Saplings too, we have done it. 1, 2. At page 62.
Yes, I've said that's indicated some recommendations, highlighted the recommendations I have said.
On the highlighting board.
Highlighted the recommendations. The after taking note of the action taken report and the order of the Honorable High Court passed in criminal revision application dated 23rd of June 2022, observed that since the Honorable High Court had already taken cognizance of the matter and issued appropriate directions, nothing further remains for adjudication in the said original application, and accordingly the same was disposed of. Paragraph. Thereafter, the petitioner prayed for permission to lift the logs from the tea estate. The where is the permission granted? The divisional forest officer, Kashian Division, by a letter dated 19th of January 2024,
Before that, Malak, may I? Before that, there was an inquiry was conducted.
I will come to that. It is his case which I am recording from the writ petition. Directed the petitioner to submit a compliance report on the recommendations given by the committee constituted by the Honorable Green Tribunal. The petitioner claims to have complied with such recommendations and by a letter dated 1st of April 2024 intimated the Divisional Forest Officer, Caution Division, that 400 Upi trees in Shorini Tea Estate has been planted between 1st of February 2024 to March 30, 2024. Paragraph. The grievance of the petitioner is that the subdivisional land and land reforms officer issued a general notice for open public auction to be held on third of April 2024. Stop. However, the auction did not take place on the said date, and a further notice of public auction was issued fixing the date of auction on December 30, 2024. Paragraph. The petitioner has prayed for issuance of a writ of mandamus commanding the authorities to set aside the public auction held on December 30, 2024 for sale of failed trees/logs within bracket Rupi lying at Shorini Tea Estate, and for a direction upon the respondents to allow the petitioners to lift from a sale and move those failed trees lying at the said tea estate, and also to issue transit passes in favor of the petitioner, number 1, for moving those failed trees. The petitioner has also prayed for an interim order restraining the respondents from interfering with the peaceful possession of the petitioners over failed trees/logs within bracket Thupi lying at Shorini Tea Estate. Paragraph. Mr. Rai Lanet, Senior Advocate appearing for the petitioner, submits that Section 5 of the West Bengal Trees within bracket Protection and Conservation in Non-Forest Areas Act, 2006 within bracket for short the 2006 Act. Police Department, Mr. Rai submits that. Section 5 of such and such Act empowers the competent authority to grant permission for felling trees. Section 5 within bracket 1. he refers to the second proviso of section 5(1) in support of his submission. Refers to the second proviso and submits that insofar as the district of Darjeeling, this is Darjeeling, insofar as the district of Darjeeling is concerned, the riot can obtain permission under section 4 capital A of the West Bengal Land Reforms Act 1955, read with Rule 474 of the West Bengal Land and Land Reforms Manual 1991. He submits that the district magistrate granted permission for felling of 515 shade trees in favor of the petitioner in terms of section 4 capital A of the 1955 Act, and such permission is still in force, and such permission has not yet been set aside, has not yet been revoked by such authority. He further submits that the allegation of illegal felling of trees in the tea estate has also been taken care of by this honorable court in the criminal revision application as and the learned tribunal. Full stop. He submits that the petitioner has complied with the recommendations made by the committee appointed by the learned tribunal.
No, it is not appointed by the tribunal.
I somewhere found
No,
that
it is the appointed by the DFO.
all right.
By the authority, state authority.
I think in the order I have seen that somewhere it has been.
Yes, yes.
আচ্ছা কি বললাম ওই কি হলো made by the committee for plantation কেটে দাও for plantation of the required number of dhupi trees, and having complied with such recommendations, the authorities ought to have granted permission to the petitioner to lift the trees and grant transit passes. Mr. Roy further submits that all that I have not gone into who has said committee's recommendation for plantation. I have kept it aside.
Not by the tribunal.
Are not said by anyone.
I have said.
Yola? So right. Mr. Rai further submits that unless and until the petitioner is held guilty of any offense under any provision of the statute, the logs in question could not have been put to public auction. Yes, Mr. Raj, these are, yes.
Other one advantage say that this DA4 say that only shed trees under the act is not correct. Is it say?
Where is the order of the DFO that?
First, this is not order, is
No,
body
that,
memo.
yes, that memo,
That's 14.
page 14 of that, is document.
Second paragraph, third, last two lines.
Mr. Rai further submits that the only basis of the issuance of the memo dated 1st of June 2022 is that the trees in questions do not belong to shade trees and the 2006 Act only provides for felling of, provides for felling of only shade trees. He submits that 2006 Act does not provide for, does not define the shade trees, and it only specifies trees in general. Next. The learned additional advocate general submits that the second proviso to section 5 within bracket 1 of the 2006 Act.
First, I have relied document, my lord, then
I will come to that. Submits that the second proviso to section 5 within bracket 1 of the 2006 Act empowers the authority to grant permission under the provisions of section 4 within bracket capital A of the 1955 Act, read with Rule 474 of the West Bengal Land and Land Reforms Manual 1991. And by taking this court through the provisions of section 4A, comma, and the Rule 474 of the 1991 manual, as well as Appendix VII 7.
27. Chapter 27. XXB.
No, chapter 27 is 474. Yeah. Appendix 7 is and Appendix Roman 7. He submits that the second proviso of section 5(1) shall apply only in case of felling of one tree and for domestic use only. By referring to the notification dated March 1, 2007, issued by the Government of West Bengal Forest Department, the learned additional advocate general would contain that the divisional forest officer is the competent authority in the case on hand to deal with the application for felling of dhupi trees. He submits that the petitioner did not obtain any permission of felling from the divisional forest officer, and the district magistrate was not competent to grant permission for felling of dhupi trees.
The trees more than one.
Of dhupi trees, of trees more than one tree, and which are also not for domestic purpose. The learned advocate, the learned additional advocate general has filed a bunch of documents containing various documents starting from the application made by the petitioner for felling of shade trees, the permission granted by the district magistrate for felling of such trees, and several documents issued by the divisional forest officer. By placing reliance on the letter dated 1st of June 2022 issued by the divisional forest officer, the learned advocate general would contain
Additional. You
submits that on field verification it was found that 253 numbers of dhupi trees of plot number 769 was recommended for felling, which were not shade trees, and there were no tea bushes present beneath the trees. Paragraph. He further submits that the goods which are lying in the tea estate are perishable in nature, and for the purpose of securing the value of such goods, the authorities decided to conduct public auction. First up, he submits that the public auction has already been conducted as per the general notice for public auction, and the highest bidder has already deposited.
No, well, partial to definitely at the time of participation, partial definitely, and when we
All right,
same manner they will deposit.
all right, deposited. Public auction has been conducted.
Highest bidder has been allotted.
What has been allotted?
As he stood as the highest bidder,
allotment
letter was-
Highest bidder has been selected.
allotment letter has been issued.
Allotment letter has been issued.
No contract is they are giving.
Allotment letter has been issued.
Contract has not been.
All right, I am recording his submission only. The public auction has been conducted. Public auction and allotment order has already been issued to the highest bidder. Paragraph. In reply, Mr. Rai Lanet, senior advocate appearing for the petitioner, seriously disputes the submission of the learned additional advocate general.
Their own letter. He said contract has not been signed.
Where?
Allotment contract
Page 29. Last page.
Contract has, he says allotment. He says, which page?
Page 31.
From my document, I say.
Will not? Seriously disputes the aforesaid submission of the learned additional advocate general and submits that it will be evident from the documents filed by the additional advocate general that no agreement between the highest bidder and the authorities have yet been entered in.
That is in February.
Yes, yes, said your documents from that. It has been. Correct.
আমরা 30 পেজের জন্য ধরে ফেলেছি এত সুন্দর কই না আমার বাড়িতে ঢুকি চলো ঠান্ডা নাই
After hearing the learned advocates for the respective parties, this court finds that several issues arise for consideration in this writ petition. Some of such issues are indicated hereinafter. Number one, whether the district magistrate was authorized to grant permission for felling of dhupi trees, for felling of 551 numbers of shade, sorry, 551,
515
oh, 515 number of shade trees. 515 of shade trees, which is lying in the tea estate, including dhupi. Whether, number two, whether the failed trees automatically, the failed trees becomes the public property for which public auction could have been conducted. 3. Whether 2006 Act
public auction for the purpose of as it is a perishable in nature, not for the public property.
It is his contention that
His contention, and we have not done the public property or the government property.
Advocate General cannot do that public auction. Anyone's property, you have to either you have to confiscate, illegal confiscation, then public auction. Otherwise, you cannot hold public auction. Can you auction a private property for public auction?
No. As it is a public property, this is the
yes. So as it is a public property, so unless it is decided it's a public property, you cannot hold that. So whether those goods amounts to public property, that is to be decided. That is the issue which I have made. Yes. Whether 6th Act provides for any felling of shade trees or not. Now, whether 2006 Act defines the category of shade trees. Such issues cannot be decided without exchange of affidavits. Stop. In view thereof, let affidavit in opposition be filed by the respondents. Additional, please take your seat. There is something more. let affidavit in opposition be filed within three, within 3 weeks, 3 weeks from date, semicolon, reply thereto, if any, be filed within a week thereafter. Mr. Parties will be at liberty to pray for inclusion of this matter in the list of hearing immediately after expiry of the period fixed for exchange of affidavits. Paragraph. Now this court has to consider as to whether the petitioner is entitled to any interim order.
Because in their own document, they say reserve price is 12908. Take note.
Paragraph.
Also, I say even they have not challenged the letter of 21st February 2022.
Take all these points, it will be decided. Now I am only on the interim order. It is not in dispute that the district magistrate granted permission for felling of 515 trees. The divisional forest officer on field verification found that 253 number of dhupi trees of plot number 769, which were recommended for felling, were not shade trees, and since the 2006 Act provides for felling of only shade trees in the tea garden, the felling permission needs to be revoked. So, after going through the 2006 Act, this court is of the prima facie view that there is no mention of any shade trees in the 2006 Act. This court is therefore of the considered view that recommendation for revocation of felling permission only on the ground that 2006 Act provides for felling of only shade trees is beyond the scope of the 2006 Act. In course of argument, the learned additional Advocate General could not produce any document to show that pursuant to the recommendation made by the Divisional Forest Officer, Kashtian Division, to show that pursuant to the pursuant to such recommendation, the district magistrate has revoked the permission. That apart, if the contention of the learned additional Advocate General is to be accepted, that as per the 2006 Act, the Divisional Forest Officer and not the district magistrate was the competent authority to issue the permission for felling of dhupi trees. What was the trees?
Trees, more than one.
Trees more than one, comma. What was the necessity for the divisional forest officer to recommend for revocation of the permission by the district magistrate? This document prima facie, from this document, this court is of the prima facie view that the divisional forest officer was also of the view that the competent authority to issue permission for felling of the trees was the district magistrate. Stop. Paragraph.
As the district magistrate issued, the revocation has to be done by her only.
These are prima facie observations, not final. At what point of time these trees were felled? Time limit?
No, it was in 19.
19. Mr.
No,
Rai?
no, 22. March 2022.
March 20.
22.
Felling.
Already
22. April 22.
It has to be because the time was extended.
No, time was extended for TP Miller, transit pass.
No, that heading on. Heading out page 34 money?
34 of what?
Of the writ petition.
Of the writ petition. That is your statement.
No, that dog.
34.
The remaining Miller, filling remaining. Can we see? Remaining number of trees.
Alright,
So the already, when the DFO has conducted an inquiry through his officer.
In 2022.
2022, he saw that already it has been.
So prior to 2022. Prior to 2022, prior to June 2022. It is not in dispute that the trees were felled. It is not in dispute that 253 number of dhupi trees of plot number 769 were felled prior to June 2022.
Yes.
The public auction was conducted only on April 20, only on, what is the date of? The public auction.
For the public auction, it was recommended, Milord, in the.
No, the date, what is the date? Of holding.
Thereafter,
When the public auction, last notice.
no. The first, the.
12/2/2024.
No, not, no.
Yes. Page number 92 of the writ. 92.
First 22, my 19 document, page number 19.
Page number 19.
My document.
Yes, your document.
Page number 19.
No. I'm asking you when the public auction was conducted.
Public auction was
30th
conducted
December
in
2023.
23.
No.
Date.
That I'm saying, Milord.
No,
Because
that notice, show me that notice.
Page 92 by lot 3.
Page 92.
Of the writ petition.
No, Mr. Chaudhary, please come to page 92. This is the last auction notice.
Yes.
Last auction of first, we have initiated first way.
No. Initiated. Auction was held on 30th of December.
Yes.
Last what? Yes, that is what I am saying. That is the only auction made.
Yes.
Auction was made only.
No,
But
you
we have
took
made
steps
we
earlier.
have made an attempt.
Process.
Yes. That you have made. You know,
26,000.
only on 30th of December 2024. To stop. Paragraph. However, till date, though the learned additional advocate general would submit that the allotment letter has been issued in favor of the highest bidder, but it is not in dispute that as on this date, the goods are still lying in the property of the tea garden. Full stop. Therefore, it is this court is not inclined to accept the submission of the learned of the contention of the state that the public auction had to be conducted only on the ground that the same was perishable in nature. It is not in dispute that the petitioner did not participate in the said auction. This court therefore feels that the petitioner is entitled to, this court is inclined to grant an interim relief in favor of the writ petitioner. There shall be an order of injunction restraining the respondents from respondent authorities or their main and agents from lifting and or moving the failed trees or logs within bracket Dhupi lying at Shourini Tea Estate till what was the time for affidavits? 3 and 1 2 weeks, 1 week, 4 weeks, 1 month, till the end of May 2025 or until further orders.
Then Malik,
whichever,
one thing kindly record. They will not claim any damage.
or until further orders.
Because my auction lifting, then thereafter they will go.
Or until further orders, whichever is early.
তোমার কাছে থাক করে।
Gustav. It is however made clear that the petitioner shall not be entitled to claim any damage for loss in the value of goods in the meantime.
Grateful, Malik. Grateful, Malik.
Yes, summer vacation.
Grateful.
Summer vacation.
Prior to that will be till that, you can apply before that. And 4 weeks will end on আজকে কত তারিখ? 10. So 10th of May, it will end. So you'll be having 2 more weeks. What is the circuit bench at that point of time?
May not be just before the vacation in May.
Before the vacation, what is the
13th May.
13th? So you will be getting that week.
Yes,
13th May. 13th May. Grateful, Malik. তোমার কাছে পড়ে থাক, তুমি শান্তি থাক।
Next
What is the next matter?
That is my fourth, my lord, now.
No.
My lord, my. My.
I take next.
Next,
Item number 27.
27. What is 27?
But here only there is no scope injunction. So adjudication is required regarding subsidy of tea garden. Many matters I filed it
Regarding?
subsidy of tea garden, non-grant also.
Yes, who is appearing?
It's over there. Can you take it? Next.
27, as paid for by the learned senior advocate for the petitioner. This is better before the next available circuit bench.
After tree, it is tea. It leaves nothing.
Yes.
Item number 30 to 40, Lordship.
Item number
30 to 40, Lordship.
Lordships, I have Lordships.
30 to 40.
30 to 40, Lordship, one matter.
Vilas, I am.
Lordship.
My lord, your lordship was pleased to pass over matter in the.
Item number
11.
11. What is this matter?
Extension of interim order.
Extension of interim order. You are for the petitioner.
I am for the petitioner.
There is the allegation.
Just see the attitude of respondent pushing aside the petitioner. My lord, protect me.
Lord, I am.
So when the
My senior is there, Mr. Majumdar.
my lord, ESG, WG, but B29 senior.
Age,
Yes, yes.
age.
Contempt matters 47%.
My lord,
My lord has now concluded a lengthy hearing, so I am apprehensive to move your lordship.
Mr. Dhos says it's a short matter, you do not have any plan. Unauthorized construction.
Yes.
Show me your
Yes.
plan.
My lord, let me open the case, my lord.
You have the plan.
No, my lord, let me come. This.
Yes.
Now as if we are seeing, as if we are viewing a cartoon movie. My lord, this hotel.
Why have you not filed the reply? Mr. Dhor is.
My lord, we want a small extension. Reply is all ready. Only affirmation ready.
Ashok, item number 11. You have filed an application for extension.
Yes, ma'am.
This can 2 of 2022-2025. This is an application for extension of interim order. Mr. Dhol, honored advocate, appearing for the Siliguri Municipal Corporation. Appearing for the Siliguri. Who is the private respondent? Mr. Dhol, honored advocate, appearing for the Siliguri Municipal Corporation, and the learned advocate appearing for the private respondent seriously opposes the prayer for extension of interim order. Mr. Dhor submits that till date, no affidavit in reply has yet been filed. First up, the learned advocate appearing for the petitioner prays for extension of time to file affidavit in reply.
Any date, next virtually ready.
Within a week.
Even if your lordship directs me to file it tomorrow, I am in a position to file it, but that won't have held up.
All right, so within a week you file it. On the prayer of the petitioner, time to file affidavit in reply is extended by a week from date. First up, since the interim order, when it was passed initially?
Lordship. 28-21. 28-1-25.
Since an interim order was passed on
initially on 28 January 2025.
28th or 24th? Oh, 28.
28, my lord. Thereafter extended, my lord.
All right. Since the interim order was passed on 28th of January 2025, and the same is subsisting till date. It's subsisting.
Yes, my lord.
And the same is subsisting till date. This court is inclined to extend the interim order. First up, the interim order already passed and is in force. Is further extended till the end of June 2025 or until further orders, whichever is
they're running a hotel from there.
Or until further orders, whichever is earlier. First up, list this matter before the next available.
But they will never get the petition heard.
Why?
They will go and carry.
My lord, he is looking at the mirror. Mr. Demolition thought is looking at the mirror.
You have allowed this, Mr. Dhor.
I'm not allowed.
What were you doing when this construction was made?
Earlier there was a construction that was gutted in fire.
What you were doing? What your councillors were doing in that ward?
We have given them stop work notice. Order has
could not implement the stop work
My
notice.
lord, there is
One
not
day,
one single document.
A huge hotel cannot be constructed. What you are doing at that
And
point
that
of
too,
time?
my lord, from 1964.
No.
Don't tell all these things to this way. You are responsible for this unauthorized construction. Now, after it has been constructed, he will say demolished. Why did not stop that?
Already order was that they went on the construction. In each time order has been passed.
No, there is an injunction running on the.
Yes, yes, call the next matter.
Yes, my lord. I'm on behalf of the petitioner. Respondent was answering respondent was.
This is that yes. Bill. Where is the answering respondent? There is no one to answer.
Yes, he's coming. He shot one day accommodation.
Yes, yes.
Not tomorrow. I'm
yes, yes.
available.
What is your instruction? Why are you not releasing the amount?
Instruction is that erstwhile Pradhan who gave this
I told
letter,
you the Pradhan has in the meantime changed.
this letter
that is
was
the reason for withholding this.
This letter was not in a prescribed form, Lordship.
What letter?
And thereafter, Lordship, change of hand was there.
What
And-
change of hand?
Lordship, kindly see.
What is the nature of the work he has done?
Nature of the solar panel, solar lights were fitted.
Were fitted?
Yes.
Is it existing or it is not existing?
No, not existing. They have already, the battery, they were not in proper way. They are fitted. It has already.
That is a different thing. That work was done.
Work was done not in proper manner, Lordship.
Not in
That's
proper
why
manner. Show me that it was done not in proper manner. Who has said that? Nothing on record.
This completion certificate and
Completion certificate is there.
not only that, 1 minute, my
Now,
lord.
if tomorrow you
This
are
is the-
changed, another person will
This
say
is
yes,
the-
yes,
my
everything
lord.
has been done.
This
This
is
is
the matter.
the erstwhile Nirmal Shah who gave this at the
What
time of
Imam
change.
Shah? You have got no electrical engineer at all.
This is
Either-
a chair.
he
He is not in person.
Your panchayat having no SAE
This is
of
what you are
electrical.
trying to show by this.
Lordship, completion certificate was given by the Pradhan. At the time of giving completion certificate, there was no inspection. After
Who is responsible for that? Who is responsible for that?
later on, inspection was done
You
by.
pay, recover from the erstwhile Pradhan. I will allow you to do that. Recover from the erstwhile Pradhan. You pay the amount to the petitioner, recover it from her.
The amount is not admitted, so their read court has no jurisdiction. They have to file.
How much amount you are admitting? Some amount? Tell me what is the admitted amount?
I have to take instruction.
The petitioner has paid for an order directing the respondent authorities to release the payment for the work done by the petitioner pursuant to a work order issued by the Panchayat. First up, paragraph, the learned advocate appearing for the Panchayat authority submits that the petitioner has not performed the work to the satisfaction of the authorities. First up, he however submits that the claim made by the petitioner is not an admitted claim. First up, the respondent authorities are directed to file a report in the form of an affidavit with regard to the issues raised in this petition. To submit such report in the form of an affidavit be filed within a period
7
of,
days, not 4 weeks. My lord,
within a
7.
period of
We
2
are
weeks.
waiting so long.
Within a period of 2 weeks from date. To stop, list this matter before the next available circuit. Yes.
Section 30, I appear for the petitioners.
Yes.
Section 30 to 30 is the same issue. We can take serial 30. It is the same issue in all the matters.
What is the issue, Mr. Kanodia? At 4 p.m.
It's a GST refund matter. Lordship, it is matter was first listed on last Wednesday. My learned friend took time to take instructions. Then it came on Tuesday. I came physically. Somehow it couldn't reach. Yesterday they were not available. So today, Lordships. Lordship, the issue is it's a single issue. Lordship, in GST, there is a board circular for refund. That in case of export, what is the process to claim refund? And one has to file an application to seek such refund. In all these cases which is listed with your lordships, there is no dispute that we have refunded, we have exported the goods. Now department is stating in the refund rejection order that because
what is the order which you are challenging?
Lordship, the order is at page 76, and the
Page
discussion
36,
page 76.
70. Page
76. Lordship, the discussion and finding starts at page number 87. Kindly takes page 87, Lordships. 76 is the form, 87 is the discussion and finding. I'll just read 2 paragraphs, Lordships.
Sound is not very much. Sound is not clear.
I'll just read 2 paragraphs, Lordships. What does the learned adjudicating authority holds in my case? My lords are at page 87.
Yes.
Lordships, page 87, discussion and findings. I have gone through the instant application of refund claim along with available documents, the reply to the show cause of the applicant and the records available.
What is the ground for
I
rejection
find that
of
the
the
taxpayer
refund?
was requested to.
What is the ground? Show me the
Lordship,
ground.
the Lordship, only ground is at page number, Lordship kindly takes page 91, last paragraph. Page 91, last paragraph.
91.
91, last paragraph.
Yes.
Last paragraph. Only, Lordship, I find that there are some instances during which goods when exported can liable to be re-imported due to certain reasons like poor quality or quality not as per order, deficient quantity or rejection or any other reason. In that case, in most of the cases, the exporter is either re-import the same or sell the goods to another party without re-importing the same. In some cases, the goods can be re-imported partially if not required by the importer or in excess quantity or payment has not been made by the importer. From the above situation,
Actually, we are only wanting the Bhutan export documents because this is the high prone revision item.
my lord,
Because
my lord, Lordship, I am audible, Lordship.
Yes.
The issue is this Bhutan custom declaration. This Bhutan custom declaration is a document, is not under one. It is the importer who has to file this document. Now they say you bring this document from Bhutan and submit as a claim of proof. There is no allegation against me that I have not exported the goods. But they say you bring this document, Lordship, it is beyond the jurisdiction of the officer to ask this. My lord, sir, my lords can hear me.
Because this is the import declaration document you were
Lordship.
directed to produce.
Lordship, but I cannot produce this because it is the responsibility of the
Let them
importer.
file affidavit. Yes.
Lordship, kindly appreciate, Lordship.
Let them file a report, it will be considered. Yes.
Lordship, there are
report in the,
Lordship,
the
5
petitioner
crore
has
refund is.
paid- The petitioner has paid for.
Lordship, there is no allegation against me. Lordship, kindly
All right.
appreciate this.
Mr.
Lordship,
Kanodia, there is no scope to pass any interim order at this stage. The petitioner has paid for a direction upon the respondents.
Lordship, they are written that it is presumed. There is a base of presumption an order has been passed.
Has paid for setting aside of the order, rejecting the prayer for refund. Full stop. There is no scope to pass any interim order at this stage. The respondents are directed to file a report in the form of an affidavit within a period of 2 weeks from date.
my lord, only one thing, because we are having some reports from the overseas.
Yes.
So it has to be given in
Lordship,
Lordship,
this is the question, Lordship. How can GST law cross the India territory, Lordship? How can the Indian territory be crossed?
That report you file on the you file a report in the form of a statement. These stats, other things you can file in the seal cover thereafter. So now, within 2 weeks from date, list this matter before the next available circuit bench. Yes.
It can be 3 weeks, my lord. 2 weeks.
Lordship, 5 crore refund is due, Lordship. The department is creating a mess throughout.
Yes.
Mess throughout, Lordships.
Yes.
Lordship, the department, Lordship, kindly grant only 2 weeks.
Okay.
2 weeks. 2 weeks. 2 weeks. All right. 2 weeks. Yes.
Grateful to yours. Grateful.
Yes. From 30 to 40.
30 to 40, Lordships.
30 to 40.
Lordships. Much obliged, Lordships.
30 to 34, which are
Give your appearances, give the numbers.
Grateful to your Lordships. Always a pleasure to.
All the 4 PM matter.
At least my physical appearance would be purposeful.
Purpose cannot be decided. How can it be decided?
That matter is not maintainable. That is why.
Why?
Administrative tribunal.
Administrative tribunal is not functioning.
Yes, it is functioning.
How
Absolutely.
many members are there?
Only one member, but
So-
functioning.
This matter cannot be decided by one member.
It can be decided. At that time,
My lord,
when
the
it
matter
was,
filed,
when,
Please, that is why
yes,
don't take this point. It's not 1 minute matter. Since the tribunal have to, whether the tribunal is effectively functioning or not, you have to consider.
it is functioning.
So that is to be considered, whether it's functioning or not. If it's not functioning, then 227 is very much maintained.
By division bench,
my lord, may I?
by the division bench.
My lord, may I hand over the
Consider.
L. Chandra Kumar, my lord?
Division bench is after the tribunal division.
After the,
My lord, your lordship knows. Till my satisfaction, my lord, may I hand over L. Chandra Kumar?
Where is the petitioner?
must be online.
Notice, my lord, was served.
Yes, where is the petitioner?
Always, my lord, trying to, my lord, delay the process. Always, my lord. For last, my lord, 3 months they
My lord,
are,
I will not say anything, my lord, regarding the, my lord, the steps taken by the petitioner or whatever, my lord. Kindly appreciate my difficulty.
Yes,
My difficulties, my lord. My difficulties, my lord. The for the, my lord, holding a selection in the pharmacy college. For the
where is the writ petition? What is the issues in the writ?
Read petition, my lord, said that the composition of selection committee has not been constituted in terms of the statute. One hand, the other hand, they have challenged the functioning of the board, and that composition of the board is also not in adherence to the provisions of law and the notification time to time passed by the government. এদিকে আমার রিকোয়েস্টটা বের করে দাও।
he was a participant, my lord. After, my lord, being, my lord, unsuccessful, they have been open eyes, everything he has participated in interview, and they are taking, he is taking point. That too, my lord, he was not at all an eligible candidate for the post even, as per the advertisement. My lord is looking to 214. WPA 214. Contradiction. 14. In open eyes, he has sit for in the examination.
The selection process for the purpose of appointment of
Lecturer, senior lecturer, and principal. My lord, in the college of
petitioner
the
is,
pharmacy college.
yes. So petitioner applied for the post of
Lecturer.
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 Not for the senior lecturer, not for the principal.
So what is the interim order which has been passed?
Interim order said, my lord, Justice Gangopadhyay, that if any appointment order has not been issued, my lord, 4th August 2022.
4th August.
Kindly excuse my lord, it has been marked in pencil.
No, that is there now.
খুঁজে পাবো না। আমার কাছে চলে আসছে।
Lordship got it? May I hand over my copy?
Kindly excuse, it has been marked.
Page 2, first paragraph. Page 2, first paragraph. Parties,
Yes.
parties are not sure whether any appointment has been made in the advertised post 2019. If no appointment is made against the said recruitment process initiated 2019, until further order by this court, appointments cannot be given in these posts. This is this, my lord, my lord, the interim order, which is continuing.
From 2022.
My lord, may I indicate one thing? I will protect the petitioner also. My suggestion would be, my lord, because he has applied in the post of lecturer. So he cannot be any grievance with regards to the senior lecturer as well as the principal. It is not a public interest litigation. He was unsuccessful in the interview. He has come up because, my lord,
What is the challenge? What is his challenge?
yes, kindly come, my lord, paragraph. In 2000, repetition 2014. My lord, kindly see the ground.
Para 7. Para 7, my lord.
Na ground se.
Para 7, he says the interviewer was not expertise to take the interview.
No expertise, expertise, not no expertise or no expert.
No expertise. The respondent authorities have no expertise and or qualification in the field of pharmacy and has no qualification to decide or judge the interview. My lord, from the state opposition, I find, my lord,
And we have disclosed each and everything, my lord.
those are the persons, my lord.
Just a second.
Yes.
So take them.
This interim order is continuing from 20.
My lord, may I submit?
My lord, interim order is continuing. True, my lord. But we have disclosed by an affidavit
Alright, so
the
I'm directing
allegation.
this matter
No, my
to
lord, kindly.
cannot be vacated in this.
My lord, I'm not asking for vacation. Let his position be protected because he has challenged. He has participated in the post of lecturer.
No, because the entire selection process has
Then,
been
my lord,
stalled. In the year 2022, you did
Then
not so long.
then,
From
my lord,
2022 till 2025,
I understand, my lord.
nothing.
No, it is not a case of nothing till 2024. We have not. My lord, kindly appreciate, my lord, that the institutions are in the threat, my lord.
Alright.
I have no problem.
So I'm directing this matter. I'm keeping this matter you mentioned in the next circuit.
Then, my lord, then these appointments shall be kindly allow us. My lord, otherwise,
I will record your submission that the learned additional advocate general submits that the interim order is seriously affecting the functioning of the pharmacy colleges. Is seriously affecting the functioning of the pharmacy colleges. First up, he prays that the interim order may be modified to some extent. First up, however, considering the fact that the interim order is continuing from
2020
from 4th of August 2022, this court is not inclined to modify the said order at this stage without hearing the petition. First up, the learned additional advocate general submits that the petitioner has been notified. However, none appears for the petitioner. First up, this matter under the heading. Now, let the matter retain its position in the list of the hearing list. The petitioner will be at liberty to. Liberty is necessary. If it is in the list, you can pray. Take chance in the first thing.
my lord, I have filed even the CAN 1 application today. CAN 2.
CAN 2 will be taken up. List the petition along with. So, shall I direct this matter to be placed under the heading application?
Application.
All right. CAN 2.
CAN 2025.
Who has filed?
My lord, the state.
Board.
The recruitment board.
The recruitment board has filed an application being CAN 2 of 2025. First up, let this application appear under the heading application before the next available circuit bench. Application heading.
But even on the date of application, the writ petitioner was not eligible for any post advertised.
Conserve your energy. The next circuit.
My lord, I have conserved my energy since 2023, my lord, when I have filed an application for
Yes,
addition of.
any short matter.
My lord, may I take back the judgment? which
Yes,
I-
yes, this order.
Uh,
Order.
Okay.
Il Chandra Kumar.
Oh, it's on the.
8 hours.
Lordship, contempt matter, 47 Millard. This
Yes, Mr. Ghosh.
is taking advantage of his right.
Yes, yes.
Millard, 54 and 55 Millard. Mr. Chaudhary is opposing me. Mr. Chaudhary is opposing me.
54 and
Millard,
55, what is this matter?
Millard, this matter, Millard, I won't take more than 15 minutes, Millard. If Mr. Chaudhary agrees, Millard, if Millard kindly takes it tomorrow, Millard. I mentioned this
What is-
Monday.
What is this matter?
Millard, an operational setup, Millard, has been shut down by the government when they issued by the forest department.
First day, next circuit.
Millard, kindly.
First day, next circuit bench.
My lord, one small indulgence, lordship.
Then Millard kindly records it in the order, Millard, so that I can, Millard, at least mention and tell the
Mr.
honorable
Mr.
judge.
Ghosh, it will appear in the list, it's appearing in the list. So I think your position will be somewhat upgraded because many matters have been
Millard,
disposed of in the meantime. So 54,
Millard, 54 and 55.
sir, applications.
It's an application, yes.
What-
My lord, may I have your lordship's
Millard, I have prayed
indulgence?
for by way of a CAN application, Millard, I have prayed for modification of the, Millard, I have status quo.
Main
and-
matter has to be heard, Mr. Ghosh. Can that be modified? If an interim order is
This,
continuously.
it's not an interim order, Millard, they have the honorable division bench. Millard, the honorable division bench, division bench granted me the liberty to take protective orders from the honorable single judge. I preferred a writ petition. Subsequently, on the first date, Millard, the interim protection, the order was not considered. Millard, only it was simply adjourned. In the meantime, Millard, they proceeded to implement the order. I am saying, Millard, kindly put me into status quo ante. If I have a prima facie case,
Status quo ante, Mr. Ghosh, it requires a detailed in effect, consideration of the merits of the.
prima facie case has to be considered. That's why, Millard, I said 15
Prima
minutes.
facie, it's in the nature of mandatory injunction.
Yes.
Status quo ante.
Yes.
So, level is to be very high. Get that.
My lord,
So,
one small
instead of that,
indulgence, lordship.
The main matter can be a part.
Millard,
It's better.
Millard, but there's no direction for it.
Affidavit has not
No,
been
no,
explained.
nothing.
Affidavit,
Not
legal direction be given for affidavit. That would be better.
No, Millard.
They don't know.
Millard, let that application be considered. If Millard kindly records one line, Millard, liberty to mention before the next circuit bench, Millard. Kindly, Millard, that much Millard can grant me. Millard, I have mentioned this on the Monday when your lordship sat first. Only that much.
The Mr. Ghosh, learned advocate, appealing for the petitioner.
Petitioner.
Praise. Cites the urgency involved in this matter. So in view thereof, leave is granted to the petitioner to mention this matter before the next available.
Yes, grateful.
My lord, one small indulgence, lordship.
47 contempt matter, Millard.
Yes, contempt matter.
My lord, only one, my lord. My lord, only one.
Don't have any other matter.
My lord,
That's why I'm leaving.
my lord, only one request.
My lord, one small indulgence, lordship.
My request for the separate order because some of.
Item number 30 to 40.
In order, all your.
Practically, my lord, 6 matters were interested to me and 5 matters were interested to my, to Mr. Agarwal.
The appearance is no difficulty. Yes, yes, yes.
But,
Millard,
But
47.
but my,
Yeah,
my
your
prayer
lordship
is
was
to-
pleased to give an order while considering the writ petition number, Millard. 60 of 2024, Millard, and page number 14 onwards, Millard. I have attached the annex order, Millard, and this.
It's an application for, this is an application alleging willful and deliberate violation of the order dated January 10, 2024. The learned advocate appearing for the petitioner submits that the said order has been duly communicated to the alleged containers, but till date, the order has not been complied with. Mr. Petitioner is directed to serve a copy of this application upon the Pradhan. You have not implemented the Pradhan by name. How can it be? Contempt has to be by name.
Maybe allowed to amend the title.
You know the name.
I don't know the name.
Then how can you amend?
I'll find out the name. Maybe.
File a fresh application then.
Tomorrow, my lord, I'll file the. Tomorrow I'll correction.
My lord, may I have your lordship's kind indulgence, lordship?
Yes.
My lord, may I have your lordship's kind indulgence?
For restoration.
54.
51.
51.
अरे हम बोल रहा है वो म्यू मतलब वॉल्यूम डाउन करके रखा है किया को बोलने के लिए बोलो ओ आई एम सॉरी
Yes.
My lord, may I have your lordship?
51. I told you.
Have you solved the other side?
Lordship.
Who is your other side?
He's
Yes, yes.
prisoner.
What is this matter? Recalling, I know. What is the main matter?
Lordship. It was allowed and the respondent supposed to file the affidavit in service. One order has already passed, Lordship, in the month of January.
Where is that order? Show me that.
Lordship.
Twenty 14 date. How can this be granted now?
It is already allowed.
You want answer scripts to be produced. Answer scripts for 10 years. Show me the rules for preserving these answer scripts for 11 years.
Lordship already.
There is no rule if it is destroyed. Madam, there is a rule for preservation of answer scripts for a specified period. Answer scripts cannot be preserved for.
Lordship, as per my knowledge, Lordship, the order has granted by the principal bench in this case.
Madam, kindly appreciate that writ petition of the year 2017. And you are coming in 2025. 2024. So, how many years? 10 years. Very difficult. Restoration, madam, is not a matter of course. I take up the main writ petition. It's not piecemeal. I think it's better you take your chance before the next circuit bench. I think it's better. Because so far as this court is concerned, I do not take up restoration piecemeal.
What about the order dated 9 January?
9 January, show me that this point was raised. I'm taking this point. Satisfy me. Point of limitation. Several judgments of the Honorable Supreme Court. It's a discretionary relief. Court can.
Lordship, then keep this.
Thank you, madam.
Your lordship,
Your Lordship,
Every day you are
Lord-
saying my matter is not being reached. When it has been reached, now you are praying for next circuit.
Your Lordship,
My lord,
despite
may I-
the order date,
Restoration, I am very liberal, but I take up the main matters.
Your Lordship,
Entire thing will be disposed of. Not pencil, restoration, again keeping it pending for 10 years. No.
My lord, item number 48, my lord.
The Ashun. All right, not today. थोड़ी देर ही तो है अलग चौदह पाँच का.
My lord,
Your Lordship.
One minute. Item number 48, the can application. My lord, here.
Next circuit bench.
My lord, kindly take it up tomorrow. My writ will be filed. My writ petition will be filed.
Your Lordship, one mentioning, despite of the order, Your Lordship, despite of the order dated 7th April 2025, this matter should be listed today, but it's not. Your Lordship, kindly,
What is this matter?
it's a new motion, Your Lordship.
My lord, may I address your lordship?
It's
This is
not
my junior
in today's
addressing
list,
my
but
lord.
it's supposed to be.
I do not know whether I'm audible.
WPS 655 2024.
Yes,
I do
it
not know.
appeared today. An order has been passed today.
No,
itself.
it's not in
My
the
lord,
list.
655 of 2024 did not appear, my lord.
Mr. Bhattacharya, there was by mistake, it was made of 2025, but the file of 2024 came. Today an order has been passed.
Oh,
It will
my lord,
appear in the next circuit bench.
my lord, may I very humbly ask for one indulgence? I cannot see your lordship because the
I can
screen
very
is-
well see you can make your submissions. I can hear you also.
My lord, I'm grateful. My lord, serial number 96. This gentleman is a more than 94 years old person.
Bhattacharya,
My lord,
yes,
he
sir.
might not make it to the next circuit.
Yes,
Lordship,
yes.
very small short point
Tomorrow
involved.
it's difficult, Mr. Bhattacharya.
1 minute, my lord, I will take only 1 minute time. Because my lord, the gentleman
Mr.
might
Bhattacharya.
not make it to the next circuit.
Mr. Bhattacharya, tomorrow it's very difficult because the motions, first time motions are to be taken up.
This is first time motion, my lord.
No.
This is a first time motion.
Tomorrow's what is coming up for the first time tomorrow.
First time, my lord. This is running in the list, never
Yes, it's
called up.
running in the list, but Mr. Bhattacharya, those who have given in the presentation form for tomorrow, that is to be taken up. Then I have to proceed serially.
I understand, my lord. Lordship, only in this case,
Nothing will
I would
happen
not
1
have-
week. Yes.
It's better not pending for submission of our affidavit. It is permitted to be submitted today.
You can serve a copy upon the other side. All right, when it will be taken up, you find.
I'm grateful to my lord. আমি তো দেখতে পাচ্ছি না, যাই হোক, ঠিক আছে, ছেড়ে দাও।
Automatically list में आएगा ना next circuit.